I always wanted to serve on a jury.
I'm really super excited to be here, so I really appreciate you having me. I'm looking forward to it.
Creating this whole trial, Daddy.
I want to give a big shout out to the 13th Jury Podcast and Brandy.
Yeah, I applaud you guys. Keep doing what you're doing.
That every time you run into Phil Barber, you should reach for it.
And then I just looked to the jury, and it's sort of like, look.
I was in the eye of the storm, and you guys were watching the storm.
Hey, if your porter works, come pop in and say, hey, what's up?
You are a ray of sunshine, and I love what you've done with your YouTube channel.
Good morning. Good morning. Gotta get all my settings redone. This drives me crazy when I come back from doing other things. Good morning. Hello, everybody. That light, why is it on? There we go. There we go. I don't like lights in my face. Good morning. Good morning, my people. Hello. I am sorry that I missed yesterday. It was unexpected. And honestly, I will probably miss some of today. I will be here physically, but I'm on a lot of medication right now. So okay, so what had happened was, hold please, let me show you. See my fancy new shoe? That's what had happened. I need to come up with like a much cooler story for how it happened, but honestly, I ended up getting an infected toe because my lady that does my pedicures cut my toenails too short, and I got an ingrown toenail, and it got infected, and I had to have part of my toenail cut out at the hospital the other night, and so it's super cute, rocking the, can you see my, let's see, this is what happens when I'm on medication, and you can see, like, I've got, like, hold on, I'm not gonna be on Feet Finders anytime soon. What was it? Feet Finders, Feet Fondlers? What was the one that, anyway, so that's my exciting story. That's why I missed yesterday. I had it cut out, part of my toenail cut out the night before, and yesterday I had to keep my foot elevated, and then I had to do a telehealth appointment at the doctor at 10 over all of this, and then I tried to watch, and then the medicine just knocked me out. So that's where I was yesterday. I feel like we need to come up with a much more exciting story, so feel free to fill in whatever exciting story on something that sounds much more glamorous and exciting about how I hurt my foot, and we'll go with the best story. Yeah, we definitely need to make a more interesting cover story. So we'll just have whatever interesting cover story we can find. We'll make it much more glamorous and exciting. Shark bit my toe. That's a good one. That's a good one. That is, yeah. Super medicated. Yeah, I went from being unmedicated Brandy to being super medicated Brandy. So I will tell you that we will try to follow everything that we can on here, but I also I'm gonna have to go back and listen to this again to be able to really get most of it. I'm sure, because I'm used to being unmedicated Brandy where we go on field trips, and this time I'm super medicated Brandy where I'm just right here, but I'm not really here. So my toenail has been rehomed. Yes, only half of it. Only half of it. My poor little rehomed toenail. May it rest in peace. Josh Canoni drove over your foot. That's a good one. That was, I'm sure she would like to. Brennan would probably like to, especially after the last few episodes I've done on him. So let's talk about that. So full disclosure, I will need to go back and watch some of yesterday. or watch yesterday again, because like I said, I was kind of in and out and I missed some of it, but I do want to talk about some of that. Melissa Filson, welcome back, Melissa. And Christine, member for 16 whole months. Happy memberversary. Happy memberversary. I thought today was a PM start time since AJ has to be in federal court today. So they have to be in federal court this morning. That is correct. And they are supposed to be starting at 11 a.m. Or whenever AJ and Alessi and the defense team get there. But they have it scheduled for 11, I think is, unless it's changed since I went to sleep. I went to sleep very early. That's at least one perk of them having to medicate me is that I have gotten good sleep in the last couple days. Oh, baby alligator, and we have a lot of baby alligators at Chat Daddy's house. Actually, I say baby alligators. There's one, that, is like a 10-footer that was in the neighborhood, and this lady in the neighborhood took a picture and put it in like the, how there's like the neighborhood Facebook group, whatever. Not here at Chat Daddy's, but it was a 10-footer. Oh, crazy. I love the gators. I just try to keep Lucy away from them. Queen Oliver Thammer for 22 whole months. 22 whole months. Chloe bit me. Bless it. Bring out the dental indentations. Let's check it out and see. Yes, they are still currently in federal court, so it's going to start a little bit later. I think they had it on the schedule for 11, so I figured I'd go ahead and start it like 15 minutes before that, because depending on when they come in, I do want to talk about yesterday since I had to miss yesterday. Wild Child member for 21 whole months. Has it been this long? Thanks for yay. I know. Time flies when you're watching Justice. Hopefully watching Justice. Sometimes it doesn't feel very justicey, justice-like. Let's see. Oh, Boston Justice is live tweeting federal court. Looks like federal court is still going on. Yeah. Which is fine, which I still wanted to go ahead and start because, like I said, I wanted to talk about yesterday and then just kind of catch up with y'all a little bit too. Helena Handbasket. I love the name. Helena Handbasket. I've remember for 5 whole months ish. I've been here much longer than 5 months. Yeah. Lurking in the shadows. I sure have missed your face, Brandy. I have missed y'all too. I'm glad to be here. Mary Murphy, member for 11 whole months. Good morning, Brandy, mods, and chat. I know it's been a whole lot longer than 11 months because I've got half gray. There you go. Oh, speaking of, okay, I guess not really speaking any of that, but I have Lucy girl here. I have her little, oh, yep, there she is. Lucy girl. There she is. Look at her little, oh, look at that baby. Look at that sweet baby. Oh, no, I'm not talking to you. Lay back down. You're fine. You're fine. I was just telling them how pretty you are. That's all. I know y'all like, when I go back to Chat Daddies, I'll take another, I know I have another camera around here somewhere. I'll take another camera for to make a doggy cam there too. But the doggy cam there might get a little wild because we have Emmy, Tinsley, and Lucy there. So she heard her sister's names. Now she's like, what? My sisters? My sisters? Actually, Chat Daddy sent me the cutest picture this morning, and Emmy and Tinsley are laying in my office. They miss me. Big old dog party over there. PJ Wolf, hello, member for 17 whole months. How does it go by so fast? How does it go by so fast? Thank you for being a member for 17 months. Little B, hello, Little B. Gifted 5 memberships. Thank you so much. Thank you. Thank you. Candace off. Candace, Candace, how much, when's your, we need a vote. When, is your voting over? Where's the vote? Hold on, let me look. Do we have more time to vote? Let's see. I know I saved the link somewhere for the, I want to vote if it's still Can't we vote again? Can we go vote again? We can vote again, right? I don't see it. Can we vote again? Send me a link if we can vote again, and we'll vote again for Teacher of the Year. I thought I saved it, and I don't see it. Unless it's over. Dang. Where is it? I could have sworn I saved it. Okay, maybe I didn't. If you have the link for Teacher of the Year vote, send it to me so I can vote again. We can share it. We got to get our Teacher of the Year. Oh, no, that's not it. I thought I just found it. Okay, I guess I'm going to spend the whole morning looking. All right, send it to me if you have it. One of the mods, or put it in the link. Or chat, not link. Put the link in the chat. You know what I mean. Oh, super medicated brandy. Mildred, hello. Just tell people you injured at training for the Olympics. That's a good. Oh, you know what I could be? I talked about this before. You know how I love receipts. So you know how like the Olympics ribbon dancers have like the ribbons? I could just have my ribbon of receipts and be like, that's what I could be in the Olympics for. I would love that. Melissa feels over for 10 whole months. Love you, Brandy, and our 13 juror family. I love you too. I love you too. What medications am I on? Like in general or just today? They gave me, I don't know, some kind of, I have to take something from where they cut me, like a antibiotic thing. And then I have to take some kind of pain medication because it sure is hurting. Melissa Filson, we love you. Tripped over Brennan. Yeah. One thing I did, okay, so I didn't see everything yesterday, but one thing I did see was I noticed that he did that whole thing where he tried to make it out to be like the defense was arguing about the federal investigation on the 18th, and you know he was like, oh, and you know, and it's even more nefarious, or however he says it, you know, that and egregious that they were saying this and the investigation is over, but he hadn't told them that the investigation is over. Once again, misrepresenting things to the court. I don't trust him. He's a snake. If you trust him and you think he's amazing, that is fantastic for you. More power to you. I don't. I'm not going to pretend to. I don't like him. The fact that he has misrepresented some really important things and then gaslights everybody else about it is really, really frustrating to me. I don't like him. I don't like his style at all. At all. And I would love to be like, you know, so mindful and so demure, but I'm not. I'm so pissed is what I am. So I'm not going to be able to pretend like he doesn't drive me crazy. I don't like the way he moves. He's smarmy mob lawyer, and I don't like him. I don't like them. If he were a defense attorney, I would think differently about him, just because I would feel like, you know, his obligation to his client is, you know, whatever. I might not like it, but we've said it before on here, like, you know, you may not like the attorneys, but, you know, they fight vigorously for their clients. I get that. But he is supposed to be, in this case, a representative of justice and, you know, and that's Don't like him. Not a fan. Not a fan. Yeah, he's the most slimy, dirty dog I think I've ever seen in a courtroom. Yeah, he's... Ugh. Brennan's keeping the Commonwealth theme of hide and seek. And that's, I think, I think one of the things that frustrates me the most about him is that not just that he's doing this, but then he gets up there and acts so self-righteous and accuses the defense of doing all the things that he's doing. And that's what really bothers me. Like, to pretend like you're not doing anything when you're like you could literally use his own arguments against him. And I did in the last episode. You can use his own arguments against him for everything. But it's like he doesn't even, either he doesn't even realize how ironic he's being with his hypocrisy, or he doesn't care. But either way, I am not a fan. Not a fan. Yeah, Lally is boring and incompetent. Brennan is slimy and sneaky. I would rather have I would rather hear, it's snowing and there's high top tables, and hear all about the Canton girls varsity basketball team seating arrangements than to have to listen to this goofus misrepresent things and then try to walk it back like, oh, my bad. Not a fan. Boozy Beauty had a great video 8 days ago about Hank's beef with the feds. Very interesting. I have not seen that yet. I'll have to look at him saying, having had a little history with the federal government, I had a feeling there was more to this story, so I reached out. You had a feeling there was more to this story because they turned over Discovery, doofus. Sorry. Oh, unmedicated brandy, unfiltered brandy. And member 21 whole months. Love it here. We love having you here. We sure do. We sure do. Let's see. I'm going to pull up. Oh, also, did you see that the juror that Turtle Boy, I was about to say Carney, because in the podcast I call him Carney. It's his name. Because I'm all formal and stuff, But did you see that the juror that he interviewed did an interview with Boston 10? I haven't seen it yet. I had all these things saved and then ended up, this medicine made me sleep a lot yesterday, which is good. I ain't complaining about that. All right, let's see. Who'd you say was tweeting the, Boston Justice. Let's see. Judge Saylor says he will issue, this is for the federals. Judge Saylor says he will issue his opinion as quickly as I can under the circumstances. Mr. Weinberg said, it's a wilderness. It's a thick forest anyway, judge notes. Okay. Interesting. So it looks like they may be finishing up there. Maybe. Trying to see what else they said. Reed's attorney, Marty Weinberg, gets to respond to the Commonwealth, says law doesn't bind the federal court from looking at this record. So it's J.M. Lawrence. It's at Boston Justice on Twitter that was tweeting, if y'all want to look at what was said. What they tweeted. I won't go through all of it, but it looks like they're wrapping up now. So, all right, so let me get my feed pulled up and we'll go ahead and start watching and waiting on that. Watching and waiting. Debut. All right. That pulled up. So we will wait for that to come on. All right. So yesterday, let's talk a little bit about yesterday while we're waiting. Make sure I have that on there. All right. Yeah, I'm not holding my breath on that either. It's one of those things that they have to go through the process. Knowing what should be done or what could be done and what has been done and what will be done, it's disheartening to think. But, you know, at least, if nothing else, I hope that all of this shines a lot of light on the situation. Did you catch Joe Flipperhead's tweet? I love me some Joe Flipperhead. I love it. Love it. His stuff is really good, and he's also really funny. Hank accusing David Unetti of going on court TV when it was actually a Zoom hearing that was played on court TV, and Hank doubled down when tried to correct him. No, I did not see that. I remember bits of it. Like I said, yesterday I was kind of out of it, but I do remember there being something about that, and I remember Hank said something about there's not a TV in the thing. And I remember thinking, as I was like kind of dozing in and out, like, oh, I need to go back and figure out what they're talking about. I'm assuming that might be it, but no. I'm hoping that today, probably not today, probably tomorrow, since we're not streaming tomorrow. But probably tomorrow I'll go back and watch that one and make all my notes. And then we can I'll add that all to the podcast, of course, but then we can talk about it Friday when I've actually been able to have a good chance to see it. Or maybe we can watch some of it at lunch today. We'll see. We'll see. It's not like I can go for a long walk at lunch with my fancy new shoe. Oh, I changed my... Hey, Nancy D. We are so grateful for you all being here. We are grateful for y'all being here. I'm going to get my information together for the episode. There's a hearing on Friday, and in order to get that I don't think I want to put that one on because I've been doing the episodes on Fridays, trying to anyway. Last week I did it on Saturday because last week, who listened to last week's episode? Last week was a very long episode because there was so much that happened. And I debated breaking it up into 2 episodes, and I was like, but then you'll have to wait another week to hear everything else. And then, and then that's not what anybody wants. Nobody, y'all are as impatient as I am. So I just figured I'd just do one super long episode instead of breaking it into 2. But it had a lot of stuff in there. And this week's going to be on... I think I'll wait and do whatever happens on Friday. I'll put that in next week's episode because I figure if I can work on tomorrow's episode, I'll put today's hearing, yesterday's hearing, and then anything I could find out from the federal stuff and all that. So I'll put all that and then try to get that episode out maybe Friday. And then we'll put Fridays in next week's. This is anytime they do something on Fridays, it's always a little bit harder because I want y'all to have the, most up-to-date information and breakdown on everything, but also I can't put it in there like as soon as it happens. I have to break it down and actually record it and all that. So all right, let's see. Oh, they're not doing the hearing now? I had the final pretrial hearing scheduled for Friday. She said last week. I guess if they get everything done today, they won't. Which would be great because then I might actually get to relax a little bit on Friday. Next week, I don't think there's any hearings next week. I know that there is on the 18th and 19th. They have those set aside for it, so we'll keep an eye on it. Kaylee May, hello. Remember for 22 whole months. Gosh, almost 2 years. Oh, that's crazy. Mr. Strange Brandy, love y'all. I love you too, and I am happy you're here. Thank you, thank you. I am glad you're here. Happy 22 months. Okay, so she's going to do it all today. Okay, so that's even better. Oh yeah, the docket has both today and Friday canceled, which is wrong. So yeah, we'll see. If they don't do anything Friday, that'll be great because then that will give me, maybe I'll actually get a chance to, relax a little bit Friday. All right, let me see. Oops. Making sure this feed is still. Oops. Oh, come on, come on. Stop pressing buttons, Brandy. Dang, did I really just exit out of all that? Yep, sure did. Give me one thing to do. One thing to do. There we go. Now I got it back. Look at me go. Okay. I just talked to myself while I sit here and mess stuff up and then fix it. Where were we? Okay, so if they don't do the hearing Friday, then that's fine. Either way, you'll get the episode Friday. They want to get everything done today, have the rest of the week off, and get back in court on. So wait, now they're in court on Monday? So everything has changed. Let me just pull the. So then everything has changed since the last. Yeah, last I saw it, it was, but look, they change stuff all the time. Going into this. Because I still have the 7th is the final. I don't have it. Okay, well, I don't have the newest one. Whatever, we'll see. We'll see what they say. It changes. I know that they have the one on the 18th for motions in lemonade, I think. Motions in lemonade. That's the 18th. So I will be I'll be here for those. Because I'll be out of town. I'm going to be out of town that weekend, but I'll be back the 18th and 19th. And I think that next week we don't have any hearings as of right now. And then we start, April 1st starts the trial. Now that doesn't mean the trial starts like openings on April 1st. That means that it's going to be jury selection, and y'all know how long that can take sometimes. So. Right, Bev, stop messing with our calendar dates. We got plans. Busy. I've got 2 different feeds pulled up, so whichever one turns the camera on first or has their stuff turned on first. Okay, so what else happened yesterday? So I saw the discussion about the misrepresenting. The judge said they were misrepresenting paying ARCA, or she didn't say that, but you know what I mean. She's insinuating that. She asked why they didn't turn over the record of payment along with the emails. I saw that. And then I saw Alessi arguing about who knew what and who's responsible for knowing. And then there's the whole paid versus reimbursed argument. So I saw that. And then I saw Hank's whole thing with which is ironic. So Hank's accusing the defense of being on a PR tour, but he's literally like, tipping off the news, but whatever, and using stuff he finds on Twitter in court, but whatever, what do I know? Yeah, so Tom CPU's channel said that Karen's team has left federal court and is en route to Dedham. Yeah, that last update about the one from Boston Justice that said the judge was going to try to have a decision as soon as possible. I figured they'd be heading out right after that, so it shouldn't be long. I've got the court pulled up on 2 different things. I have a bad feeling about the trial with Brennan and Bev. Yeah, I do too. And I think that all of this lately has just shown, like, even more that we have a reason to be. We have a reason to be worried, unfortunately. Yeah, Alessi is awesome. I am a huge Alessi fan. I love the way he argues, and I love his organization. I said in the last podcast, his binder with the color coordinated highlighters and tabs and all that, like, that's my love language. Like, that was my love language. Loved that. Would have been over for 14 whole months. Good morning, fam. Brady, hope your toe heals fast. Thank you so much. Thank you. It already feels a lot better today. Yesterday was rough. Yesterday was painful, but it already feels good. They're saying that court will begin in about 45 minutes. So we have a little bit of time now. They're saying they're going to do it at 11 Central. I'm like, my necklaces are all tangled right here. So we have a little bit of time. All right. So the federal investigation, they announced it was over. And by they, I mean Brennan. And a bunch of people have been asking me, like, well, what does that mean? What does that mean? It doesn't mean anything, really. All it means is that they didn't, whatever they found, they don't have enough to indict anybody on anything. So no charges are being, no charge being filed. Now, some people are like, oh, that means that Karen Reed's guilty. No, it doesn't. Their investigation was not into, well, they're never able to say exactly like who the target of the investigation was. It was just, but we have that one letter that said where, the U.S. Attorney's Office had a very different perspective of the case details than Morrissey did. Yeah. So, but they don't have enough information, or they didn't get enough information to indict anybody on anything. And that's what that means. Hopefully, what else that means is that, maybe at some point there will be a little bit more information that we're able to get from that. But right now it's still under seal. So still the same issues apply with their limitations on what they're allowed to reveal from that. Glad there's such a spotlight on this case. Me too, because Lord knows, I mean, look at some of the stuff that has come about through this case, like the stuff with You know, it's like a good old boys network up there. Nurse for God member for 21 whole months. Hello, Nurse for God. Hello. Hello. Around John O'Keefe, not Birchmore. It made me really mad too. Speaking of Birchmore, when I did see Brennan when he tried to do the whole, you know, oh, these are just hardworking public servants and they're trying to bespeak their names. Like, no. No, sir. Like this, we're beyond that. We're not in denial anymore. Like there are issues, and pretending like those issues don't exist so that you can insult the defense doesn't mean that they don't exist. And the stuff, federal investigation open or not, the stuff from the federal investigation with the same witnesses, with the Sandra Birchmore, this is not our first rodeo with this. Like we've seen there, if you have something that happens that takes into question the credibility of a key witness, especially in law enforcement, it's going to be used in trial to show the jury, you know, there's issues with the credibility of this person, you know, potentially because of this and this and this. We've seen this before. This isn't like the defense is, you know, trying to do this. They're the first ones to ever try to bring in past, you know, issues or situations with other cases. It happens all the time. It's relevant information because it's the same, like you're looking at, okay, all of these people were involved in this investigation that cleared this cop that should have been charged with murder. So if it's the same people and they have this huge, you know, spot on their record because of this case, that is relevant information. You can't pretend like it's not. And he does a lot of pretending, but I don't. I can see that, like, Brennan's just going to make me annoyed and cranky for 2 months out of the summer. That's okay. Oh. Wait, can you hear this one? I had the, hold on, let me check my settings, because I had the reduce mic background noise. Could y'all hear that? Sometimes when I have the reduce noise thing on, you can't hear it. Marilyn, hello. Member for 22 months. Miss you all. Miss Lucy the most. We miss you too, and we love Lucy. Lucy misses you. Happy memberversary. Y'all couldn't hear that? Hold on, let me, all right. What about now? Did you hear that? Did you hear that screaming goat? Can you hear me now? Can you hear me now? Kristen Limited Edition, member for 6 whole months. Sending love and light to y'all. Brainy and Lucy. We love you too. Thank you. This thing is so freaking loud. I can't believe that you can't hear it when I have the background. What else can you not hear? Did you hear that? I bet you heard that, didn't you? That was my air kicking on. The days of no air conditioner are over. March is upon us. Thank you. These are I slept too long to actually do my hair braids. Hello, hello. See, now I have the goat button that my mom got me, and this one's louder than this one. Okay, we got goat A. We got goat B. We're going to keep them both on standby just in case. I have a feeling we'll need it. Bree Breezy, gifted 5 memberships. Thank you so much. Thank you, thank you, thank you. I'll allow it. Yeah, my mom got me that Taste the Biscuit shirt too. I need something like that in merch. Oh, I forgot to add the new shirts to merch. I have one, and Chat Daddy has one. Y'all have seen me wear it before. It says allegedly on the front, and then it has my thing on the back, the logo on the back. I meant to make it public on the thing, and I will. Yeah, goat button is a must. Like, you know, like these just need to be replaced. Like the horns on your car just needs to be replaced with this. It's just. Hello, Alyssa K. No, you didn't miss anything other than my fancy new shoe. You did miss that. If I showed my fancy new shoe. Other than that, you haven't missed anything that's actually important. Now on the docket, Commonwealth's updated exhibits to motion to dismiss hearing. So they've got new exhibits for today. Today's going to be interesting. Today's going to be interesting. I'm ready for it. Kind of. But also not looking forward to having to listen to Brennan. Hank Brennan. What did I do to it? Well, if I have seen my fancy new, yeah. We're coming up with much more exciting stories. Did we pick a winner for the much more exciting story on what happened to my foot? Alligator bit it? Shark bite? Watching Nurse Kim yesterday, she said she was in court yesterday and had to make sure to fix her face. A woman after my own heart. I am also not able to fix my face. That's okay. It's all right. I had to work on that in Charlie, when I was at Charlie Adelson's trial. Fixing my face. And at Lori Shaver's. Because there was a couple times where Lori Shaver, I was like, wait. Fix my face. Husband heard the goat all the way upstairs. He called down to me to make sure I was okay. That's really funny. That's really funny. Husband and I are thinking about moving to Florida. I want to be close to the coast, but not in a real touristy area. Any suggestions? Well, both areas I'm in are touristy. This is like more small town, but it is a tourist town, obviously, because it's on the beach. But Mexico Beach is beautiful. It's not very touristy, and it's beautiful. It's near the coast. Apalachicola, all that whole area is really pretty. I'm a Panhandle girl. I love the Panhandle. I love being down in Orlando with Chat Daddy too, but oh, I love the Panhandle. Yes, I am not streaming every day. I am streaming this case. This is the only case that I can get time to stream at this moment. I have a couple of big projects, a couple of big announcements coming. Very exciting stuff, but I have been 13th juror's been busy, y'all. So I am making time to stream this one, but I have some announcements coming up in the next few weeks that we'll talk about. Orange Beach is nice. I don't know that I've been to Orange Beach. I have to check that one. I can't remember. Yeah, Panhandle is my fave. I love it. This is our forever home. I love it. Orlando's cool too, though. There's so much to do in Orlando, but then we have the Gulf here, so I love it. All right, let's see. The other, I still can't share what case it is. No, I can't share that yet. I will, though. I promise, as soon as I will. As soon as I can, I will. There's so much happening in the world of 13th Juror, and I'm really excited. There's some really big stuff with the podcast itself, and then with some stuff some opportunities that have opened up because of the podcast. So it's really exciting. It's very surreal. We just a growing. So I'll be excited to share all that with y'all soon. Yes, they are all good announcements. Very good announcements. How's my son? He's doing good. So he took me to the hospital the other night. He's the one that had to take me to the ER to get my toe halfway cut off. And he was like thoroughly disgusted. But he has taken care of me. He came yesterday, and he went and got my medicine for me and stuff, and came yesterday. So he's doing good. Lisa Dempsey, 22 months of I live here now. You live here now, Lisa Dempsey. Aw. Time goes by so fast, doesn't it? Happy anniversary. Will you be a guest speaker at CrimeCon? No, I do not. I am going to go, but I am not speaking. And I'm going to go, so I'll be there. Chat Daddy will be there with me, but I am not going to speak. I want to go and flamingle. I missed it. What did you do to your toe? An alligator bit me? Or a shark? Or Bev ran over it. That was one of the things. It's really nothing that exciting. The lady that does my toes, my pedicures, cut my toenail too short, and I had an ingrown toenail, and it got really, really infected, and they had to go in and cut part of it out. It's really gross. So now I'm just hobbling along in my fancy new shoe. So we were trying to make up a much better story, and so chat had that on lock, like doing a great job with the where is there we go. I just realized my little things aren't that are showing. There we go. I tripped over the red Solo cup that was stuck in the dang snow. Facts. And the ground was frozen. I'm not allowed to say that. Can't say fresh, can't say frozen. All these new F words. Chrissy Bacon, member for 19 whole months. No place I'd rather be. I am glad you're here, Chrissy Bacon. There's no place that I would rather you be either. That sounds extremely painful. Yes, it was. They didn't have to cut my toe, just a lot of my toenail, like half of my toenail. Like just the left half of my toenail. Holy cow, I had that done. It was a full-on outpatient surgery. Yeah. I had to yeah, it was pretty bad. It was bad. But see, it's very risky for me to do any kind of anesthesia, so they just numbed the little area. I'm a high risk for anesthesia because I've had so many surgeries. You're playing this little piggy on your toes, and you went wee 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 home with a bitten toe. Yeah, it got bad. It's a very, very rough game of this little piggy. Lucky that didn't become a staph infection. Yeah, that's why I went and got it taken care of, because I know if it got in my bloodstream, it could be bad. Yeah, once you've had too many surgeries, then you're considered high risk for any kind of anesthesia. Fun times. TB is, he's got a court hearing this afternoon. Yeah, busy week in court for all the stuff related to this, huh? Yep, there's a hearing today. The attorneys are on the way to the courthouse, or they were from federal court, so they said that they are going to start, I think, at 11 Central, 12 Eastern. Yep, motion to dismiss argument today. And what else are we? I vaguely remember hearing, and I've got the documents. I think somebody emailed me the documents. Like I said, yesterday was kind of, I was in and out of it, medicine and stuff. So, I think the documents may be in my email, but there's a Dr. Wolf that the Commonwealth has that they're going to motion to exclude. This is like the least prepared that I've been on one of these lately. Normally I'm like telling you like every detail to every document that, whatever, but that's what happens when alligators bite your toe. But I think that there was something said about that. Let me see if I can just pull. I think I have those documents in my email where somebody sent them to me. I tell you what, when y'all send me the documents to my email, I don't always get to respond and say thank you, but I love it when y'all send me those because it saves me so much work having to go get them. So let's see. Let's see, there's a motion to, let me pull up this actually. All right, 542. There's a motion to unseal portions of the audio from a motion hearing occurring on March 4th. During the motion hearing, counsels and the court engaged in lengthy sidebar conversations that were subsequently sealed by the court. The Commonwealth moves that this court unseal the recording for counsels of record only. The Commonwealth intends to obtain a complete written transcript from the motion hearing. So that was for the motion hearing for March 4th. Unseal. For these, I put them on some of them. I put them on the link to my documents on there, and some of them I just put the link to if somebody's posted it on Twitter, I'll put that because that is so much less work for me to have to add on there. And this is just a reference for me being nice at and putting it on there. All right, let's see. Hello, Tara. Thank you so much. Good to be back. I've been missing your lives. Canton Conspiracy episode with Spire. Thank you. Getting a little snarky in my old age, but that's okay. Oh, and then I saw the this is another thing. The media release from Chief Rafferty. It said, I recently spoke to and was informed by the U.S. Attorney's Office that all aspects of the federal investigation initiated by her predecessor and related to the death of John O'Keefe have been completed. The investigation is no longer active and will be closed. Due to ethical limitations, I cannot comment further. So that was Chief Rafferty's release. Chief referee. And what else? Have you hit 2 million? I don't know. I haven't looked again because I didn't want to get like too excited and upset. No, I'm at 1.99 million. 1.99 million. So I'm so close. But we did hit 32,000 on here, so that was cool. 1.99 million listens. It's crazy, right? Is that the craziest thing in the world? I think so. Since when does a chief of anything announce the end of a federal investigation? Yeah, right? They don't. Like, it's the craziest thing in the world. This just never ceases to amaze me. Let's see. There was a new Sallyport motion for reconsideration. I don't think I have that one. It's anywhere we get podcast. It's 2 million overall. Well, actually, the 2 million doesn't include YouTube. YouTube is different, and the YouTube playlist is available too, but that one is not. That 1.99 does not. So I guess technically, if you include YouTube, then I would be well past the 2 million, but. I appreciate it. Very exciting. Very, very exciting. All right, so I only have the ones that I have. Okay. Oh, take two. Let's try that sentence over. I don't have the full documents in my email. I just have like the pictures, like screenshots of them. So I'll see if I can get the full documents. I know we have to go over some of that stuff too in the next episode, because I think there's quite a few that I haven't pulled yet. I've added it to my Apple podcast, but usually listen on the tubes of you. Thank you. Chief's wording was interesting. Will be closed. That's not as definitive as Brennan's representation, but if Brennan misspoke on that, I don't see how he doesn't get. Brennan misspeaks on a lot of things, and then just it's like, oh, my bad. I get really frustrated with that. Like, really frustrated. Because I don't know how you can misrepresent stuff that's such a big deal. Because he's misrepresenting stuff about other attorneys and what they're doing. Like, he's like making big accusations about other attorneys, and he's giving false information. And I don't understand how that's not, how we're not. And I don't understand how this whole thing with the crash daddies is such a big deal. But where's that same outrage when the Commonwealth has been doing all this shady stuff for so long? I don't understand that. I don't understand why. Because regardless, okay, let's say that the defense got up there and misrepresented everything. Fine. Like, let's say they intentionally did it. Okay, fine. It still doesn't change the report that was made. So if you're looking at the overall impact on the trial, that has way less impact, and that's just assuming that they got up there and did everything on purpose and did all these things that Hank Brennan was trying to say. That it doesn't change the report that was made in February, and doesn't change anything. But look at the Sallyport stuff. Look at the withholding information on that. Look at all. How is that not? How are? It's like I'm like watching Twilight Zone. Like I don't understand how. Where's the outrage on that? Where's the judge bringing up questions about that every single time? And the fact that she's not, and the fact that Brennan is allowed to misrepresent whatever he wants and there's no kind of consequences just shows exactly where this trial is going. And I hate to say that, but I think he was brought in here to do exactly what he's doing. And I'm scared to see what he's allowed to get away with. I think that the defense has pissed everybody off. This, is one of those situations where the district attorney and all of the, everybody in the Commonwealth and the state police and all that, they've been made to look like fools because of the way that they've handled things, and they're pissed, and I think that they're trying to, they're trying to bring in somebody who can make this happen in whatever means necessary. And that's the way it feels. And I hate that, and that's scary, but that's the way that it feels. It feels like that's what's happening. So we'll see. It just feels dirty, slimy. Retaliate. Thank you. Y'all are going to have to help me with words today, y'all, because medicated, you thought unmedicated brandy was bad. Wait, overly medicated brandy, 10 times worse. Think of all the times Bev coughed at Lally and he didn't understand she doesn't have to do that with Brennan. Yeah. But did you eat? Actually, I did. So y'all know I'm really bad about remembering to do that. Factor, y'all remember when I used to eat Factor meals all the time, and y'all were like, oh, you should get them to sponsor you. And I was like, they're never going to sponsor me. They're so big and I'm just little old me. Well, now they sponsor me, which is really cool. But anyway, so I've got Factor meals, and then before Chat Daddy left, he went and got me groceries because he knows that I don't buy groceries. So I have eaten. Hello. I'm waiting. I've got live feed pulled up over here, just waiting. Waiting for them to go live. It's gonna be a good day. I need to get together. Okay, so today, depending on how long this lasts, and what I can get done this evening, today and tomorrow I will get all of the new reports, because I'll be out of my medicine fog by tomorrow. And I'll get all the new reports and go over all that stuff. And then Friday we're supposed to have the hearing. If we don't, maybe we'll do a short live to go over some of the stuff that I've missed the last couple days with the new reports and or new filings, not reports, and the hearing that I missed yesterday, when I get a chance to actually watch it without medicine brain. Hello. I have not seen you in forever and a day. Wonderful to see you. Thank you. It is wonderful to be seen. I miss your lives. I know. I miss our lives too. I've been here for all the Karen Reed ones, except for yesterday, obviously because of unforeseen circumstances. But I will be doing those. I've got some details that I'm working out about what's going to happen with the trial. But big news happening there too, so I'll keep y'all updated on that. There's a lot of big stuff happening. I can't wait to share it with y'all. You're going to be shocked when we talk about some of the changes happening around here. You're going to be shocked because I'm shocked. Did I read somewhere that Brennan is actually billing the Commonwealth about $250,000 in fees? Yeah, all that stuff about how $75,000 or whatever it was is what he said he was going to make, and I guess that's not reality, which is funny because isn't that what we all said? We're like, there are all the people that are like, oh, he's doing it, in the name of justice. I was like, first of all, no prosecutor would take that case in the name of justice. Think about how many prosecutors we've seen that have been like, there's no way. There's no way I would take that case. Prosecutors, defense attorneys who used to be prosecutors, all that stuff. Some of y'all were sending me Swan Boat Club trial stuff, telling me it's interesting. I haven't seen that, and I have no idea what it's about, but I've seen some of y'all send me some stuff saying that one was really interesting too. All right, let's see. I'm making sure I still have multiple feeds up to make sure that when they finally turn on the camera, we won't miss it. Okay. You know what we need? Brainy's meltdown moment. My goat falling off the cliff and all that. Good times. Good times. Good times. Okay, I'm a hopeless optimist. Has Bev sounded a little defeated? I think Alessi backs Canoni into a corner, goes hard, but for whatever reason, she doesn't seem to get as agitated by Alessi as Jackson. Alessi is so based in, his arguments are so based on fact, and he's such a likable guy. And not that Jackson isn't, because Bev sure don't like Jackson. But I think that he is so... he's got this humility about him when he argues things, and I think that that's very endearing. But he's also so organized, and he comes with the receipts. So there's none of that, like, where Brennan gets up there and is like, this and this and this happened, and then like Leslie gets up there and he's like, bro, here's the receipts. Once again, you're wrong. That's not what happened. And I think it's kind of hard not to like him. I will not be flying up for some of the trial. But I do have some announcements coming. I just got to work out all the details first. Who's bankrolling Karen Reed's team? Well, some of them are not actually getting paid what they're, what they should be getting paid. They've had the, people that have donated to her defense and stuff like that. That's helped help pay for the experts and the investigators and stuff like that. But her defense attorneys are not actually getting the money that they would be getting. Hello. Hello. He needs to stop acting. He needs to stop announcing that he's repeating himself, though. I understand why he's doing it, because it's like, think about like how boring these can get, and then you think about like some of the timeline stuff that Brennan just breezes through because he's wrong about it. So when I understand why he does, because he's like, well, let me repeat that, because he wants to make sure that like if you've tuned everything else out, you need to understand that like this is a date that's very important, or this is a point that's very important. Like he's wanting to stop what's happening right now, make sure you hear this part, make sure this is very clear. So I understand why he's doing it, and I actually don't mind it, because sometimes I do have a million other things going, so I don't mind it when he does it, because I'm like, oh wait, I need to be listening to this. But Bev is not a fan of that. Bev's not a fan of anything that the defense does. But she seems to love her some Brennan. I look at Lucy and keep remembering that video of her running full out when you were at Chat Daddy's. Lucy flies. She flies. She's a little superhero puppy. She flies. It's so cute. Oh, it's so cute. She does, like, she just, pew. She can outrun them big old dogs, too. It's really cute. Super, super cute. Nope, still no camera on. She is super Lucy. It's adorable. I know mass courts are crooked. Had a cell phone while driving ticket from a sting. Went to court with the bill which proved I was not using the phone. Found guilty anyway. Judge said I could have fabricated. Wow. It's not how proof of guilt is supposed to work. Better O's in the building. Still no camera on. Let me go and get this ready. Gosh. Do you ever like see somebody pop up on your YouTube and you're like, why does that person come up on there? I would never, ever watch that person. Okay. There we go. I'm interested to see the Canoni-Brennan alliance fall apart. I think she's going to end up disliking him. She's so biased for Commonwealth that she's overlooking his brazenness. He's going to make her look bad. I think he, like, I think because he's giving everybody a bad name. Oh, let me change. Okay, I'm going to change my reduced background noise. We might not be able to hear the screaming goat if I do that, but then you also can't hear my air conditioner as much. So we'll have to mute the screaming goat, but then you can hear everything else better. Which is odd. I really don't know why that doesn't seem like something that would be filtered out of background noise, but oh well. Felt like I was in tunnel. I forgot I'd turned it off so that y'all could hear the goat. But then when I turn it back on, you can't hear my air conditioner, which is good. Except for when I'm recording the podcast. The mods don't put you in timeout for posting a link. It's like an automatic thing. If you put a period and then there's not a space right after the period, there's like the Streambot or Autobot thing, whatever it is, thinks that you're trying to put a link in. So then I don't know how to make it do that. So if it's not a link, it could be just you end a sentence with the period and then there's not a space in between. It thinks that you're trying to post a link. So then it gets mad and does a thing. We've tried to figure out how to make it not do that, and I can't figure out how to make it not do that. So what's it? The Autobot, Streambot, LabBot, whatever bot, whatever it is. Yeah, it's a grammar snob. The robot is a grammar snob. It says that they should be starting right now. Oh, we're waiting. It says Jackson is leafing through a binder right now. This will be good. Oh, the Supreme Judicial Court oral arguments are live right now. Not for this one, obviously, but I still have their channel saved on my stuff so I can see that they're live. Those are interesting to watch too, because the way that the judges just interrupt to ask a question right away, it's interesting, like the way that those attorneys have to be just so quick on their feet to be able to stop mid-sentence, answer a question, and then pick back up where you left off. Like they have to know it all, be ready for it all. The appellate attorneys really impress me. Still haven't started yet. Learning to type in the 80s was very important. Remember that there used to be so many rules. I remember I learned to type on my nanny's typewriter. And if you mess up, then you take the little white out, We have another 13th juror grandbaby. Aw, Phoenix Rising became a grandma November 12th. Congrats. Our family is just growing. Oh, that's adorable. Oh. I love that. Somebody asked if, I saw it in chat earlier, somebody I was asking if one of my announcements is that I'm pregnant. No. No. And it never will be. Nope. Nope. I am, not only am I, like, no, just no. I couldn't, even if I wanted to, the chemo and radiation and all that stuff is, like, even if I wanted to, my shop has been shut down because of all that. But no, no. No matter what announcement you're going to hear from me, it will never be that. But I'm really excited for everybody else who has those announcements, but it just ain't gonna be me. That Boston's mayor testifying on sanctuary city police before the U.S. House Committee is on too. I kind of want to watch that later. Is that like a weird thing to be really interested in? Really interested in? I don't even live in Boston. I sent you a DM on Twitter of Kara Reed and her team at Federal Court. She looks so nice today, like always. Oh, I will look that up. Yeah, she has good style. That pisses a lot of people off, which is funny because people get mad over the weirdest things. Like, your announcement better not make you too big time to shun the verdict brows. The verdict brows. It looks like they've got a video, I guess a video screen. They're still waiting on Brennan to get there. They've got a video screen set up in the courtroom. So I'm assuming we're going to be seeing Sallyport videos. Hello, advocate. Hello, hello. It was very interesting. There were 5 mayors who all testified. See, I'm interested to go back and see it. I think they said 2 o'clock for his, if I remember right. But I could be wrong. Yep, we heard Bedro is in the building. It's all sanctuary city mayors. All right, so Brennan's there. They're saying we might not break for lunch. Just waiting on them to get started. And y'all, if you're just joining us, I will tell you, I am, I told the group earlier, I am on a little bit of medication. So if I seem loopy today, you get what you get and you don't pitch a fit. keep double checking because some of the things start the camera before the others. Still not started. Yeah, a little loopy today. The prosecutors filed an answer to TB's motion citing his Bang Bang intro song. I don't know what that means. Brennan, thank you. Thank you. Better is there for editing. Yeah, his is at, I think, 2 today. I am a little loopy today. Did you see where Pam... No. Sent a letter? I did not. I did not see that. Hoping that medication makes you extra spicy today. My filter has been not filtering, y'all. Not filtering. And that's okay. The Bang Bang is in their pleadings, so the Bang Bang. They're saying that his intro song is witness intimidation. Is that real? Are you being serious? That's all stuff from... Isn't that all stuff from Alan Jackson reading? Or repeating... Colin?
Best of my knowledge, signed and sworn to under the pains and
here we go.
penalties of perjury this 21st day of February.
All right, hold on. Let's... Hold on, let me go back because
multi-level.
This just started.
Multi-level hearsay suggestion that there was some sort of misconduct by the jurors or by a specific juror. We pressed the issue at sidebar and asked who the source was. At that time, there was some sort of
I'm
getting to that.
Was.
I want to go back because it just started, but it just started like in the middle of them talking.
By the court with no additional information.
No, I didn't tell you about the role. I didn't know who it was.
I'm getting to that because that was the next conversation that we had. When we were told on the day of closing argument to approach sidebar, the court indicated through multi-level hearsay, we'll all agree that it was some sort of multi-level hearsay suggestion that there was some sort of misconduct by the jurors or by a specific juror. We pressed the issue at sidebar and asked who the source was. At that time, for the first time, we were told the name Lieutenant Fanning. We obviously recognized
You were not, just
that.
so we're clear, you were not told that by me.
No, we were told that by, and I'm getting to that as well. We were told that by Ms. McLaughlin. She's the one that indicated that it was reported. I'm sorry. That's not right. That's not right. We pressed the issue on who was the source. I believe the court then inquired of one of the court officers.
Who are in charge of the jury?
Your Honor, I'm getting to that. I understand that. But if you'll allow me to make the argument and to indicate what as my declaration says, my good faith belief, based on reasonable belief, this is how we get there. We were then asked, or the court asked the court officer to join us at sidebar. He then indicated that it was Lieutenant Fanning. Ms. McLaughlin then went on to say, and by the way, he indicated that Lieutenant Fanning had reported this, supposedly gotten it from some unnamed or unidentified person. There was no evidence presented at the time, as the court knows. There was no declaration, there was no report, there was no supporting documentation whatsoever, no recording, even though this report to the court through the court officer from Lieutenant Fanning indicated that this juror may be, quote unquote, may be on a recording. And the court confronted that juror with that information. There was a brief colloquy with the juror where she said, not that I remember, no. That was the initial statement that she said in terms of any misconduct. No, I wasn't talking about the case. Over the defense's objection, this very potentially defense-friendly juror was then excused. During that discussion at sidebar, that's when Ms. McLaughlin explained for the very first time to the defense that who Lieutenant Fanning was in this circumstance. And she said that he was the, quote, commander of the extensive security operations that this case has required, period, end quote. That sentence says a lot. It said a lot to me.
It does not say he has access to or control over the jurors.
It says that
and
he has...
I'm just going to stop you. I'll let you finish in a minute.
Okay.
Mr. Yannetti, as a Massachusetts practicing lawyer, knows that the court officers are in charge of the jurors. Go ahead, Mr. Jackson.
If there is a commander of the extensive security operations over the entire case, there is, Your Honor, no greater security operation than securing the jurors. That is sacrosanct. It's paramount among the security operations that the court embraces. And we were told, I didn't make it up, Ms. McLaughlin told us. We were told he was the commander, not part of a security operation that was outside the court, not part of a security operation that helped parking cars or making sure that citizens got in and out of the courtroom appropriately. We were told he was the commander of the extensive security operations in this case. It is reasonable to conclude from that statement that Fanning was either directly in charge of the jurors, which the court is now telling me he wasn't. Again,
you were told that at sidebar that day by Ms. McLaughlin.
No, we were not. We were told...
I have the transcript.
Well, Your Honor, what we were told is what his title was. Commander of the extensive security operations of the court. So we reasonably concluded that he was either directly in charge of the jurors or in charge of the people who were in charge of security of the jurors. But we were never allowed the opportunity to find out exactly what his role was because the court didn't take evidence, refused our request at the time, in good faith. Both Mr. Yannetti and I asked the court to take evidence from Lieutenant Fanning. The court
I think it was
declined.
Ms. Little.
I'm sorry?
I think it was Ms. Little who asked me to.
And what was the court's response? The court's response was to decline that invitation. We didn't take any evidence, which would have drawn down on the issue, so I wouldn't have to make reasonable conclusions. I would actually have the information. So, of course, that's one of the issues that is attendant to our motion to dismiss, because it seems wildly inappropriate. Here's what we do know about Lieutenant Fanning. Once his name was uttered, here's what we did know. He's among the troopers that is one of Michael Proctor's supervisors. He interviewed several prosecution witnesses who testified at trial against Miss Reed, including Laura Sullivan, Marietta Sullivan, Bridget Meehan, Heather Maxson. He interviewed all of those individuals, or took part in those interviews. Lieutenant Fanning was at the defendant's home and seized her cell phone in January of 2024, just months before the trial began. Lieutenant Fanning was included on the text chain where Trooper Proctor said he was going through my client's phone looking for nudes. And then his name comes up at sidebar as the commander of the extensive security operations attendant to this case, and he's the source to whom something was reported about juror misconduct. When you couple those two things together, that he's the commander of security and a person who supposedly, through hearsay, overheard a juror making statements about the case, and they have an entire myriad of individuals to whom they could report it. They report it to Fanning, and then Fanning reports it to the court officer who reports it to the court. It is not unreasonable to conclude that he was at least within the orbit of the security operations governing the jurors, which is exactly why we put it in our papers. And without additional information clarifying that, we have no way of knowing that he wasn't involved or didn't have any direct access to the jurors. If he didn't, he didn't. And that's a fact that everybody can agree on. But when we heard the information, the only reasonable conclusion we had, given the fact that he was the source of the information and he was defined as the commander of security over the entire case, not part of the case, the entire case, which includes the jury, that is a reasonable conclusion.
So you signed your affidavit 2 weeks ago when you already knew that he did not have any access to the jurors.
No, I didn't. I absolutely did
Signed
not.
and sworn under the pains and penalties of perjury this 21st day of February 2025.
Correct. On February 21st, 2025, we were still at the first time that it was mentioned that he had absolutely no access to the jurors. He never had any contact with the jurors is when we received our responsive documents from the opposition from the Commonwealth. In that document, they mentioned he never had any direct access, he didn't have indirect access. They make these claims with no verification, by the way, no declaration, no supporting evidence, no declaration from the attorneys who filed the opposition. That's the first time someone actually took the position that he had absolutely no access to any of the jurors, direct or indirect. So when we filed our papers, the information that I just told the court is the information we were working from.
I will let you move on. I can tell you, I'm really not satisfied with your answer, Mr. Jackson.
Your Honor,
Well, put it this way. Let's say it this way. So, now that you know that he had absolutely no access to the jury, what's the nature of the conflict? How is your client's right to a fair trial jeopardized? Now that you know it's not true.
Is there evidence? My question to the court is there evidence that he had absolutely no access, either direct or indirect, with any of the jurors? I don't know that to be true. I mean, I take the court at its word, obviously, clearly.
So we will move on from that, Mr. Jackson. We'll move on from that. So
well, the court's asking what is our evidence of, or what's our indication of the impropriety of him being the person that actually reported this misconduct and ultimately leading to the exclusion of a very, very defense-friendly witness. I'm sorry, defense-friendly juror, or presumably a defense-friendly juror, and knowing at the same time that he was intimately involved in the prosecution of my client. That's the reason. Because he was at least within the orbit of commanding, according to Ms. McLaughlin, commanding the extensive security services over this case, and he ends up, just ironically, who knew? He ends up being the source of the information that got that juror removed. That's awfully coincidental, Your Honor. And yes, that's the foundation on which we built our argument that that shouldn't have happened. He certainly never, ever should have had any access, even in the orbit of the jurors, directly or indirectly, and the court never even inquired as to why he was the one receiving the report. Why Lieutenant Fanning, of all people, who then reports it to the court officer, who then reports it to the court, who then removes the juror? That's an awfully straight line between Lieutenant Fanning, who has an interest in this case, and the removal of a juror. That's improper in our view. And that's why we put it in the papers, and that's why we argued it the way we did. Because we were working off of extremely reasonable beliefs based on information that was provided to us at sidebar in the court's presence.
all right, so that's your answer to my question.
That's my answer to
May I have a
the
moment
question.
to confer with counsel?
Yes.
This is how it's going to be. Everything that's done that's inappropriate, they're going to say it's not inappropriate. And they're just going to follow Brennan's lead on trying to make it out to be like this is just the defense, trying to be the defense, instead of an attorney pointing out how wildly inappropriate and extra convenient all of these things are. This is going to be something.
Thank you for that. The court invoked Mr. Unetti and said, as local counsel, he knows this not to be true. Mr. Unetti just indicated to me that that's not quite the fact. And so Mr. Yannetti, I think, should be able to at least address the court. As the court said yesterday, when we file something, we file it on behalf of everyone, including Mr. Yannetti. So if the court would allow Mr. Yannetti to explain what his experience is, that may elucidate on this issue.
If we have time later, go on with your argument.
I'm happy to, Your Honor, and thank you for giving me the opportunity. The cumulative discovery misconduct by the Commonwealth, as laid out in our moving papers, through their agents has been both egregious and pervasive. We've outlined most of these issues in our moving papers, all of these issues in our moving papers, but I want to concentrate my argument for the court this afternoon on the exculpatory Sallyport videos. I'm not waiving any of our arguments in the moving papers, but in the interest of time and focus, I think it bears upon the court at this point to consider most prominently the Sallyport issue, or the Sallyport video issue. The Commonwealth, to start off with, two facts that are true. The Commonwealth cannot deny the untimely disclosure of critical exculpatory evidence. They cannot and they will not deny that untimely disclosure. And they also cannot deny that critical evidence was intentionally, not by some sort of mishap, but intentionally was withheld from us. So what do they do in their opposition? Most of the time they spend saying that the prosecutors themselves did not know. They had no actual knowledge. While they concede the unavoidable in their moving papers, which is that the Massachusetts State Police and the Canton Police Department both knew about the evidence and both withheld it. Conveniently, they throw much of this on the back of Michael Proctor. It was sort of to be expected. He's already damaged goods, so why not? And they also bring in a newly revealed sergeant, a sergeant by the name of D.G. Petro, who's already retired, gone from the police force, and who interestingly retired just 2 days after the Commonwealth's October 2024 disclosure revealing previously withheld Sallyport video.
I'm just going to ask, is he available, Mr. Brennan?
Not today, but he could be available.
I'm just curious, so he's still around?
He is,
Okay.
yes, and he's cooperative.
All right. All right, Mr. Jackson, go ahead.
Our motion illustrates that, and by the way, I'll walk through the videos that we did get and when we received them. Our motion illustrates that dismissal in this case is required because of the cumulative impact of clear-cut discovery violations, clear-cut, inexcusable Brady violations. And from a legal standpoint, the conduct in this case is so egregious, it's so pervasive, and it's so deliberate that prejudice must be presumed. We don't have to prove prejudice, it should be presumed. To begin, I want to start the issue by talking about the condition of Miss Reed's passenger taillight. The condition of that SUV passenger taillight at the time it was brought into the Sallyport at Canton PD is of critical importance. And that may be one of the most important facts in this entire case. It's important because we know as a fact now that not a single piece of taillight was ever recovered at 34 Fairview until after that vehicle was in the possession of Michael Proctor and the Massachusetts State Police. That is the foundation on which this entire argument is built. And it is an undisputed fact, although it wasn't undisputed for years. Other material facts that are not in dispute. The Sallyport video has been in the possession and custody and control of the Commonwealth since January 29th, 2022. That is a fact. It's also a fact that none of it, not one bit of it, was ever disclosed to the defense until April 4th, 2024. On April 4th, and I want to walk through what videos we did get and when. On April 4th, we got two videos. One was the Sallyport interior front wall. That was the video that was missing 42 minutes, which was the 42 minutes where it would have shown the car being pulled into the Sallyport. And we also received a Canton Police Department driveway video with the SUV on a flatbed, which did not show the rear end of the car. On April 23rd, 2024, and by the way, April 4th, the court will recall, was just in the shadow of the beginning of the trial. On April 23rd, in the middle of the trial, we received Another Sallyport interior back wall video. That was the video that is now sort of famously inverted. On October 10th, 2024, 2 days before Sergeant D.G. Petro retired, we received 4 videos. The Canton PD interior hallway, the Canton PD rear lot main side, the Canton PD rear lot cruiser side, and the Canton PD church side exterior Sallyport. And I highlight the word exterior because it becomes extremely important in just a moment. These are 4 videos, all of which show Brian Higgins in some way, shape, form, or fashion at the Canton Police Department on January 29th, 2022. Then on January 28th, 2025, the Canton Police Department main driveway side exterior Sallyport was given to us. It's a grainy and very wobbly video that nobody can sort of make heads or tails out of. You can see the general outline of a vehicle, but the condition or the quality is so bad that you can't tell what the condition of the taillight is, which is what we're interested in. And I bring this to the court's attention, or I highlight this, because this is the second exterior Sallyport video that we ever received. One on October 10th, one on January 28th, 2025. Then on Friday, this past Friday, something pretty remarkable happened. We just received a report from Sergeant Buchnick dated February 28th, which is 4 days ago, 5 days ago now. And he makes an important admission in that report for the very first time during all of this. He indicates that in May of 2024, during trial, he was, quote, provided with a thumb drive and the CD labeled with a Post-it note on my desk to review prior to testimony. He goes on to say, quote, at this time I reviewed the video and I reviewed video made available to me, which included video footage of the Canton PD exterior Sallyport. Exterior Sallyport. That means that the Massachusetts State Police not only had in their possession exterior Sallyport video, but they knew about it and were reviewing it during trial. But we didn't get any of it until, as I just said, October 10th, we got one. January 28th of this year, we got the other. So that was withheld from us for the entirety of the first trial and all the way until at least October 10th, possibly as late as January 2025, and they've now admitted that. But who else knew about this withheld video in May of 2024 during trial? On cross-examination...
So can I just ask, was this of better quality than anything you had had, or was it the same wobbly?
Same.
Okay.
Same. Wobbly, grainy, can't make heads or tails out of hardly any of it. No. The question is, who else knew about this? Did anybody else know about this being withheld from us in May of 2024 during trial? On cross-examination on June 6th, Trooper Buchnick admitted to reviewing video evidence with Mr. Lally in May of 2024 in prep for his testimony. Was that the video that they were reviewing together? Was it the exterior Sallyport video? We now know that Buchnick watched some sort of exterior Sallyport video. He admits it in this report that we just got 5 days ago. And we also know that he and Mr. Lally were reviewing video together before his testimony in May of 2024 because he admitted to that on cross-examination during trial. But I didn't have information about what he was reviewing because we didn't have the videos. So either they reviewed together the inverted video that was then played and knowingly presented false evidence to a jury and to this court, or they reviewed exterior Sallyport video and intentionally withheld it from us. This is binary. It could only happen one of two ways. Either it was the inverted video that they prepped on and then presented inverted video to the jury, which is a problem, or they reviewed external or exterior video and did not provide it to us intentionally. Either way, the withholding that evidence admitted to now by Trooper Buchnick was obviously egregious. It was obviously in error. It was obviously calculated. Another important material fact not in dispute, on April 10th, 2024, the DA certified disclosure of, quote, all evidence.
Can I just get back to that, what you were just discussing about May 2023?
Yes.
How is that exculpatory?
because the videos themselves, as the court will see through the presentation of my oral argument, that the fact that those videos all just happened to either be grainy, wobbly, missing 42 minutes, or from the wrong angle and flipped backward, all tend to show that the Commonwealth doesn't want the condition of the taillight to be seen by anybody when it's pulled into the Sallyport. That is a reasonable inference. In other words, it's the cumulative effect of the bad videos that helps us. That's why it's exculpatory.
All right. And also, could you explain to me the prejudice?
I will get to, yes, I will get to the prejudice as I move through
now
my
or no? If you can, if you're going to do it later, that's fine.
I will do it later. I will do it later. I think the prejudice is cumulative.
Damn.
Obviously, we didn't have the information that we needed to be able to cross-examine the witnesses that we needed to be able to cross-examine at the time that it was provided.
Okay.
It just, very obviously, there were certain videos that were clear from some cameras on other days and other times, but these cameras that were late discovery that was provided to us just so happened to all go out. They all find their way to be defective in one way or another at the exact moment that we would need them. On April 10th, 2024, the DA filed its certification of giving us all evidence that they had in their possession, and that they had done a reasonable inquiry. Both of these, that certification was just flat not true. How could that be true, and we're still getting video evidence that is in their possession, custody, and control in October, in January? How could that possibly be true? It isn't true. And it's illuminating when you look closely at the Commonwealth's opposition to our motion. First and notably, the Commonwealth makes these broad statements couched as fact. They're bold pronouncements, and there's myriad excuses in their opposition paperwork. And it's backed up by next to nothing. Not a single exhibit at the time they filed their opposition. There's some exhibits that have been lately provided, including some exhibits just a few minutes ago that they're now adding to their exhibit list and to their opposition. But at the point of fact, at the time they filed their opposition, there was no factual support for any of its positions.
So are you pointing me to something specific, or are you just saying in general and you'll wrap it up?
In general, the only thing that they had attendant to their opposition was this joint affidavit that doesn't address any of the defense allegations at all. Contrast that with the defense motion, which was supported by nearly 20 fact exhibits. There may be a reason why they didn't support their positions with exhibits at the time. It's because the facts don't support the Commonwealth's position. These are indefensible and indisputable facts that I'm explaining to the court about the turning over of these Sallyport videos. Specifically turning to the Canton PD surveillance video. The opposition says, or reads, the Commonwealth provided the defense with a...
I just always like to read along. Where does it say it?
I don't have the page number.
Okay.
It's the point at which the Commonwealth indicates that they provided 90 photographs.
Okay.
Crime scene photographs in support of the vehicle in the Sallyport. That is a distraction. What they don't mention in their moving papers is that the date of those photos were all February 1st, 2022. There are no photographs from January 29th, 2022, when the vehicle was brought into the Sallyport. The only thing we would have would be the videos, the surveillance videos, all of which are somehow, some way defective and which were held in their possession in some instances for nearly 3 years before it was turned over to us. So it's the condition of the car at the time that it was brought into the Sallyport on January 29th at around 5:30 p.m. that matters. That's the only time that it matters. The other evidence referenced by the Commonwealth about a 5 a.m. ring video and Canton police cruiser at 8 a.m. and the independent observations of Dighton police officer Sergeant Barrows, they all corroborate the defendant's contention that the taillight was cracked and not shattered at the time it was brought in to the Sallyport. And we're still talking about the condition of the taillight, obviously, when it was brought into the Sallyport. The Commonwealth next mentions that Lieutenant O'Hara from the CERT team arrives at 32 Fairview Road at 4:56 p.m. They then go on to mention that he was preceded by another trooper at 4:54 p.m. and that the car got to the Sallyport at 5:30, suggesting, obviously, that the search began and taillight pieces were found before the car ever arrived. That would be interesting if it were true, but it's not true. It's a distortion of the truth. It doesn't matter when the CERT team actually arrived and drove up there and sat in their warm cars and waited for other team members. The last team member to arrive didn't arrive until 5:41, 11 minutes long after the car had already been secured in the Sallyport, long after Trooper Michael Proctor had access to that passenger taillight. The first taillight piece was not seen or found or recovered until 5:45 p.m. after the vehicle's arrival at Canton PD. That was seen. We can see who's got access to the vehicle and who makes access to the vehicle in that inverted video. Once we turn it back around, it's very obvious. It's Michael Proctor milling about at the passenger taillight. These are important details to get right. The timing matters. The opposition claims that the defense theory is quote unquote evolving. They write that the defense, quote, struggles to establish how the condition of the defendant's broken taillight in Canton, in the Canton PD Sallyport, is in fact exculpatory. How is that exculpatory? The condition of the taillight, that it was cracked and not shattered as it moved into the Sallyport. How do we struggle to describe that as exculpatory? Of course it's exculpatory. Of course having those videos withheld from us is prejudicial. There is no struggle. It's on the video, it's on the ring video that establishes that the right rear Lexus hit the back of the Chevy Traverse, cracking its taillight. The Commonwealth, pretty desperate to ignore that inconvenient fact or that inconvenient piece of video evidence, literally previously said in open court that the Lexus only got close to the Traverse, only to be completely impeached when everybody in the courtroom at trial saw that 5,000-pound Traverse jostle, its rear wheel jostle, under the impact of the SUV right at the right rear or the passenger side taillight. Now the Commonwealth, with no factual support, no factual underpinnings whatsoever, says, okay, hang on a second. It did hit it, but it didn't crack the taillight. So whose theory is evolving? Ours or the Commonwealth's? The defense has never wavered. We knew that Michael Proctor, from the very beginning of this case, had been lying about the time he first took possession of that SUV. He claimed that it was at 5:30. The court will recall this. We had litigation concerning this. He wrote it in at least 9 reports that we were able to count. 9 reports or affidavits. Those affidavits sworn under oath, and the Commonwealth repeated that time for nearly 2 years, even going so far as to argue to this court that the defense got it wrong, that we were wrong because we failed to calculate for daylight savings time. So the Commonwealth battled us, and this is something I think the court has to really weigh and balance, the following conduct. The Commonwealth battled us for nearly 2 years on the singular issue of the time that the SUV got to the Sallyport. They finally took their medicine at some point and had to admit to the false time and chalked it up to a Scrivener's error in 9 separate documents, memorialized 9 separate times, some of them under oath. And all the while they were battling us on the time that it got there, no, the defense is all wet, they're wrong, they just didn't account for daylight savings time. Oh, no, this was just a little mistake, it's not a big deal, it was a Scrivener's error. And the entire time they're making both of these claims, they had video in their possession that established unequivocally that that car was in Michael Proctor's possession at 5:30 and pulled into the Sallyport at 5:30. They knew the time. They knew that he had retrieved it at 4:12 in the afternoon and not gotten it to the Sallyport until 5:30. So the Commonwealth was well aware in 2022, the Commonwealth and their agents were well aware in 2022 that the SUV got to the Sallyport, and that was the centerpiece of the defense case. They knew that the videos would directly impeach the lead investigator on this case, and they say that we struggle to explain the exculpatory nature of this evidence. It's not our struggle to explain it, it's their struggle to acknowledge it. Of course that's exculpatory. It directly and unequivocally impeaches their lead investigator on one of the most important issues in the entire case. And that's only one aspect of the withheld videos that also is exculpatory. The other is the point at which it would show the condition of the taillight. In other words, when it's being pulled in to the Sallyport, would it show the condition of the taillight before Trooper Proctor had access to it in the Sallyport? That's what we've been seeking. The Commonwealth is well known from the beginning of this case that the defense has demanded all physical evidence be preserved. That is, this is not a game of Wordle. This is not something that's supposed to be parsed. All physical evidence be preserved. That's pretty straightforward. The Commonwealth shouldn't be in the business of withholding exculpatory evidence by playing some sort of a gotcha game with definitions of words. They knew what we meant. We don't actually know what the Commonwealth has, so we have to be as broad as we possibly can when asking for evidence to be preserved. So all physical evidence clearly includes the entirety of all the Sallyport videos. The Commonwealth parses words by saying, well, we never asked for the Commonwealth to preserve the CPD footage from the Sallyport because the Canton PD is not the crime scene. You asked for crime scene footage, and Canton PD is not the crime scene. Well, first, I think that's a disingenuous argument that plays right into that sort of gotcha that we've discussed. I think the Commonwealth is better than that. That's not what we should be doing in a trial for murder. And second, let's not forget that District Attorney Morrissey actually defended publicly
Yes, I was hoping
Michael
you'd bring this
Proctor
up.
by explaining that when Michael Proctor said he responded to the crime scene, and of course we knew he didn't respond to 34 Fairview, D.A. Morrissey said, oh, he was talking about Canton PD, which is the crime scene. So they can't have it both ways.
Thank you.
They write on page 4 of their opposition, quote, the trial prosecutor was not aware of the existence of surveillance video in the Canton Police Department's Sallyport until receiving the federal grand jury transcript of Massachusetts State Trooper Michael Proctor, end quote. So they've taken the position, look, we personally did not know anything about that Sallyport video existing until we received the federal grand jury paperwork showing that Michael Proctor testified to it. First, the Commonwealth has to know that that is not the state of the law in Massachusetts. Massachusetts State Police and Canton Police Department are both arms of the prosecution actively involved in the investigation of this case. Not one, but two separate agencies not only knew of the existence of the footage, but the lead investigator actually admitted to a federal grand jury that he pulled the footage at the start of the case. He pulled it all. And then he said he reviewed it all because that's what the case agent does. The Commonwealth cannot absolve themselves of the egregious and very obviously intentional discovery violations by Michael Proctor, by the Massachusetts State Police, by the Canton Police Department, by saying, I personally didn't know about it. The cases are legion on that issue. Commonwealth versus Sleeper, 2002 case found at 435 Mass 581, and this is Hornbook law. Quote, a prosecutor's duty to disclose exculpatory information or exculpatory evidence extends to evidence in the possession of the police who participated in that investigation. And then Massachusetts Rule of Criminal Procedure 14A1A, the prosecutor shall disclose information covered by mandatory discovery, provided it is in the possession, custody, or control of the prosecutor. Persons under the prosecutor's direction or control, or persons who have participated in investigating or evaluating the case and either regularly report to the prosecutor's office or have done so in this case. Michael Proctor worked out of the Norfolk DA's office, physical plant. There is no question that Michael Proctor and both agencies intentionally withheld that evidence. Let's talk about Michael Proctor's testimony before that grand jury. He was asked the following question. Are you aware whether there are any cameras in the garage or Sallyport where Karen Reed's SUV was parked? Answer, yes. Question, have you reviewed the footage of that garage? Answer, I saw one very grainy video and then another of Sergeant Buchnick and I arriving in the main entrance around 5:30 following the vehicle. Question, when did you watch the video from the Sallyport? Answer, I haven't reviewed it, sir, in quite some time.
So do you have those page numbers for me?
I can get them for you, Your Honor.
Okay.
I didn't cite them in my notes.
Yeah, if Ms. Little can get them for you before you finish, that would be helpful for my review.
I haven't reviewed it, sir, in quite some time, so I can't recall what's on there. Question, why did you review video of the Sallyport? Answer, we review every video we pull. We pull a lot of video. It's on the case officer.
I went over this in the last episode.
By his own admission, Your Honor, Michael Proctor recognized himself in a video along with Sergeant Buchnick. That was likely the video that ended up being inverted by where Michael Proctor was by the passenger side taillight. And that was before any taillight material was ever recovered at 34 Fairview. That is highly inculpatory of Michael Proctor. It is highly exculpatory of Karen Reed. Another point of fact. By his statement, Michael Proctor admitted that, quote, we pulled, end quote, the video. That video is on a 30-day overwrite. The Michael Proctor testimony in front of the federal grand jury is at page 79, lines 1 through 13.
Thank you. Thank you, Ms. Little.
Exhibit C is in Charlie.
Okay.
The video is on a 30-day overwrite, Your Honor. We all now know that. We didn't know that before just a few weeks ago. I don't expect that the Commonwealth knew that either. This is new to everybody, right? But you have to have pulled the video within the first 30 days to even be able to review it. We've been getting these videos in dribs and drabs for not months, but for years. Actually, it's been months. It hasn't been years. He further admitted that it shows the SUV arriving in the Sallyport at 5:30, which means he wrote those reports and signed those affidavits, the 9 that I was talking about earlier, with full knowledge that there existed a video that he had and had reviewed that proved he was lying. It doesn't get any more exculpatory than that. And that was the video, that was the very video that was withheld from us, from the defense, for 2.5 years until the middle of trial. The Commonwealth says the, quote, trial prosecutor, end quote, was not aware. It's becoming a relatively common refrain in the opposition. That's neither a defense nor a justification for blatant and egregious discovery violations by the Commonwealth and its agents. The fact that the trial prosecutor, whoever that is, it's an interesting use of the name of a pronoun. I don't know who the trial prosecutor is, but apparently the trial prosecutor, according to the Commonwealth, didn't know anything about this. But that's not a defense. Who is the trial prosecutor? Is it Adam Lally? Is it Laura McLaughlin? Is it both of them? And why are they only referring to one trial prosecutor when there were clearly 2 in the courtroom? They make the statement with no factual support for that anywhere. Again, the only affidavit that was supplied was a type of affidavit I've never seen before, where it's signed under oath by 3 different people. So which sentence goes with which person under oath? The single declaration is odd, to say the least, but it certainly doesn't define who's responsible for what statement in that declaration. We certainly know that it was not Hank Brennan. He was not involved in the first trial, so it can't be him. The Commonwealth writes, quote, the prosecutor had not been alerted to its existence by investigating officers, end quote, but claimed that on April 4th, they promptly presented the defendant with 9 surveillance videos in its possession. The Commonwealth received the federal materials.
Were those all from the Canton Police Station?
I'm sorry.
Were those all from the Canton Police Station, those 9 videos?
My understanding is those were from the Canton surveillance. They're talking about the Canton. I didn't go back and audit which 9 they're talking about because I thought we only received 8, but I believe they're all from the Canton.
Ms. Little, were they all from the Canton Police Department?
Yes, Your Honor.
Okay.
The prosecutor had not been alerted to its existence by investigating officers, but on April 4th, they promptly presented it to the defense. The Commonwealth actually received the materials that highlighted the fact that these existed in February of 2024, probably around February 21st, 2024, because that's when both sides got all the federal materials. That is not prompt. We presume that Mr. Lally has daily communications or had daily communications with Michael Proctor as the investigator, the lead investigator on the biggest case that the Commonwealth, this office of the Commonwealth has seen in a long time. And it took 2 months to produce an incomplete production of these videos. We didn't even get all of them at the time. The Commonwealth writes, quote, "The quality of the video is poor in certain portions. However, this is the condition it was recorded in." Says who? That's a fact question, one that needs to be answered. And it's an important question. Who says that the Commonwealth received these, or I'm sorry, who says that this is the condition that those videos were recorded in? We've got no facts to support that whatsoever. And then the Commonwealth goes on and says, and that was the condition in which it was received by the prosecutor. That's also a fact question that needs to be answered. And these questions could be answered with a proper evidentiary hearing. The Commonwealth's representations about Louis Jutras, the technology director for Canton, being subject to cross-examination about the Canton PD video surveillance system is also just not true. They indicate, well, we had access to Louis Jutras and could have cross-examined him on all of these issues. Louis Jutras was called for a very specific reason, the town library video. We had no way of knowing at that time that he had any connection whatsoever with the Canton Police video system. We were not told that until well after trial. That was never disclosed to us. And I think Mr. Brennan used this phrase not long ago, that would have been nice to know of Mr. Louis Jutras. The first time Louis Jutras was ever disclosed as the person who installed the cameras at Canton PD was in a report dated October 10th, 2024. According to Colleen Crawford, and the court's heard her name as well, one of the Commonwealth's experts, Jutras indicated that he replaced and disposed of the camera capturing the inverted video at some unidentified point between January 29, 2022, when the inverted video was actually taken, and July of 2024, because it was quote-unquote defective. Interestingly, that's the only video that's clear. It's inverted, but at least it was clear, and that's the camera that, according to the Commonwealth, was replaced as defective. A week after filing its certificate of compliance, after the defense brought to the court's attention that 42 minutes was missing from the Sallyport video that we did receive, lo and behold, the Commonwealth produces a new video that also purports to show the passenger side taillight, except, as the court now knows, that's the one that was inverted. In the moving papers, in its opposition papers, the prosecution says, well, the prosecution had not previously received this video or knew of its existence. This is now the third or fourth time the Commonwealth sort of runs to this argument, I didn't know. We did not know about its existence. No matter how many times they write it, however, it does not change the Commonwealth's responsibilities. It doesn't change the prejudice that the defense suffered. We should have had these videos at the very beginning.
So, Mr. Jackson, I'm just going to ask you how much longer, this is the luncheon recess, but how much longer are you going to be?
Probably 45 minutes, I would say.
All right, so we'll break.
What? Polarizing?
Y'all, that's wild. I'm sorry, but that's wild. The way that she interacts and the way that she responds to the defense versus the way that she responds to Hank Brennan. Bro, Hank Brennan got up there and told you that, you know, like, made you get all up in a tizzy because he said that, you know, the feds had to turn over information that the defense was hiding, made you get all up in a tizzy over that. And we're cool because he was like, oh, my bad. I was wrong about that, along with some of the other things I've been wrong about. All of those misrepresentations, like, and she's like cool with him, but Jackson gets up there to argue this, and she's just can't be bothered. She's annoyed. She's in a hurry. She doesn't want to hear it. She interrupts him. She, like, it's, I have tried to defend her recently. Based on some of the, you know, some of the stuff she, like, some of the rulings she's made recently, I've said were fair or whatever. But how do you justify that? I don't get it. I don't get it. I think if it were me, I would be pissed that the Commonwealth is withholding evidence, which is a huge deal, misrepresenting things, making all these big allegations with nothing to back it up. They've already screwed the pooch on the whole defense, or not defense, on the whole timeline thing with the defense. Like, they've ruined that a couple times, and that's cool. We're cool with that. But when Jackson gets up there to argue about them, like, they're literally withholding evidence, and we're just going to pretend like that's not a big deal and we're annoyed to be there. I don't understand how that's, I don't understand that. I don't get it. I really don't. And I mean, it's honestly, it's scary that this is just how it is. Advocate, thank you. Sitting Jackson a hug train. I mean, he's such a good attorney. So I feel like where I would probably get snarky and be like, oh my gosh, you know, lady, who do you think you're talking to? I don't even know what to say. Like, it's just crazy to me that it's just nice. Like, they're not even trying to hide it anymore. Not even trying. Little B, thank you for the super sticker. Thank you. Thank you. Thank you. Thank you. I'm like, I don't even know. I don't even know what to say. Okay, so let's recap a little bit. The stuff with Lieutenant Fanning. Okay, so let's go back to that. So when it first started, the judge was reading from the defense's motion about the jury tampering stuff. Now, I said in last week's episode, I was like, you know, this is what we're hearing from this. This is what, you know, we're hearing from this. But because all of the jury stuff is secretive, you know, I said I didn't want to speculate too much on that because I don't have a way to verify, you know, anything because it is so secretive. So we can only go by what we're hearing. Now, normally you can go by what you're hearing in court, but then you look at the things that are being said in court and the things that are being said in these filings, and you realize that you can't go by what we're hearing in court. So, so I want to, when I'm getting the podcast stuff together, I'll go back and listen to exactly what was said, but just as like a, like, kind of recap. You know, she's saying that, she said it's simply not true that Fanning had any kind of control over the jurors. And she asked about the, you know, the, now that, she asked Jackson, you know, well, now that you know that he didn't. And Jackson's like, but there's no evidence that he didn't have any kind of, you know, what are you going to do? Go by what Brennan says? Look at what Brennan's been saying. Brennan's full of crap. You can't really go by what Brennan says. Brennan isn't truthful. So you can't go by what he says, and he wasn't there anyway. The direct line that he's talking about is, if, you know, they didn't know that this whole story that ended up getting this juror dismissed came from somebody who had supposedly told Fanning this. Okay. Do we not see that that's a problem? Like, if you're do we not see that that's a problem? Like, this is the guy who is Proctor's supervisor. He didn't have a big role in this case. That's true. Like, he was there for some of the interviews or whatever. He didn't have like a big role in this case, but he obviously is Proctor's supervisor. He was in that text string. They did an internal affairs investigation, you know, to him that was closed because they said that they did not have enough information to prove or disprove what was being said. So if they can't prove it, they can't disprove it. All they can do is, you know, close it. But to find out that the juror who, even reporters in the room were saying, you know, like, you can tell that this specific juror is disgusted with what Proctor's saying and like the things that are coming out. You can tell like by body language. Remember when I was at the Charlie Adelson trial, that one juror that I was like, oh yeah, that one's definitely pro-defense. And I was right. Like, he ended up being an alternate and then was pissed, and, you know, anyway, it's like you can't always tell with all of them, but there are cues that you can pick up on. And they had said that this juror that was dismissed was obvious, you know, based on body language and stuff, that they were leaning towards defense. And then Fanning, Proctor's supervisor, is the one who is like, oh, you know, there's hearsay about this. So it's like, it's all hearsay. You don't need any kind of evidence about it. You don't need any kind of proof. You don't need any kind of anything. And it's all based on something that Fanning said that was based on hearsay. And then they just want the defense to be like, oh yeah, trust us. We say that nothing happened. I don't get it, y'all. I really don't. It honestly is a little bit scary. And it's to see that the prosecution's getting away with doing whatever they want to. Whatever they want to. And defense is like not even allowed to argue without being interrupted and talked down to, and I don't get it. I don't get it. But she's apparently annoyed about the jury stuff. She said that she was not satisfied with his answers, talking to Jackson, and said that there was one of the reporters in the room was saying that she would shake her head and like close her eyes when Jackson was speaking. Nothing to see here. But yeah, she said now that you know that he didn't have access to the jury, and Jackson says, is there evidence of that though? Is there, are we supposed to take your word for it? We took the Commonwealth's word for it that there was no more Sallyport evidence to turn over. Look how that's turned out. We took them at their word that, that they weren't withholding anything. Look how that turned out. Took them at their word that the video is accurate representation. Look how that turned out. If you're constantly proving that you can't be trusted, how are they going to trust you? So, the exculpatory Sallyport videos, let's take a look at that too. I put it on Twitter. I've not been good about putting stuff on Facebook, and I'm sorry. And I know some of the mods have screenshot it and put it on Facebook for me because I have been failing at doing that as much as I should be. But I do have some of the oh shoot, it's not what I wanted to go to. Stop pressing buttons, Brandy. All right, so here's let's see. This is okay, so this is the Sallyport video stuff that he was talking about. All right, so you can see the court ordered the Commonwealth to turn over all video footage to defense along with metadata. That was from one of the general preservation, discovery, request issues, whatever. They were supposed to turn everything over, right? That was October of 2022. Ironic, because now they're still getting stuff. All right, so April 4th of 2024. So this is right before trial starts, right? Let me zoom in a little so y'all can see. It's too much. All right, April 4th, 2024. The first set of video that they turned over comes in. It's got the missing 42 minutes when the SUV arrives. So, who is Fanning? Fanning is Proctor's supervisor. He was in the text about still looking for nudes or whatever, but he was on vacation apparently when the text was sent, so he didn't respond. So, they closed his internal affairs investigation because they didn't have enough to prove or disprove that he was unsatisfactory as a supervisor. And he's also been involved with Aiden's case too. So, all right. So the missing 42 minutes when the SUV arrives came from that first April 4th situation, right? So April 10th, the Commonwealth files a certificate of compliance stating that the defense has all the evidence. They said that they turned everything over. That's April 10th. Then April 23rd, the inverted Sallyport video is brought to the defense. This is after they had already started trial. They started had their trial date start was April 17th, I think is when they started jury selection. Gosh, I can't get words out, y'all. Medicine brain. They started jury selection, so I don't know that that's the exact date. I know it was sometime around there. So, but the trial had already started, so they get this. The reason they got this is not because they did their jobs. because we all know how that goes. Not because of that. The defense got up so after they got this video from on April 4th of the Sallyport where the missing 42 minutes. David Yannetti gets up in that hearing and he's like, oh, they finally give us this video and it's missing these 42 minutes, the exact time when it would have come in. Remember, we were watching and we were like, oh my gosh, that's so crazy. Of course it's missing the time right when it would come in. Well, then Tully sees that and is like mad at Yannetti for, insinuating that there's missing footage from this time because they're going to use it in their third-party culpability, all that. So he talks to Chief Rafferty, and Chief Rafferty's like, nuh-uh. There is video of when it comes in. Here, I'll send it over. They should have it. Y'all should have it. I'll send it over. So they send over more video. Okay? So it took Yannetti pissing you off and pointing out that your video is missing footage for you to actually do your job and get more footage. Okay, whatever. So then that's how they got the Sallyport footage. Because then Chief Rafferty's like, I'll send over more of what we have. So she puts everything on a thumb drive and drops it off at Massachusetts State Police. All right. Then October 10th, this church side exterior, the first floor corridor, the rear lot main side, the rear lot cruiser side, all those videos are turned over on October 10th. Those are the ones that they said showed Higgins. All right. Here's another problem. All of these were apparently done after the first trial. Chief Rafferty pulled these in August of 2024 because Higgins got up there and said that he had gone to the police station to move his cars because of the storm, whatever. So in August of 2024, Chief Rafferty is somehow able to go pull these videos that show Higgins from February or January 29th. They had to have been pulled sometime between January 29th and February 28th. So where were they? How come you all of a sudden have these now? How come you can pull videos from that far back if it overwrites? How can you go pull those now in August? So then she goes and pulls those in August, but then they don't get turned over till October. Then there's another one that's turned over in January 28th of this year, from the main driveway exterior, the SUV being brought into the Sallyport. Appears to show an individual approach the right rear taillight immediately when brought in and exits shortly after. So that one's another one that was turned over. Oh, it was put in a file. Didn't see it. How do you have all of this? And it takes, other people, like how? And this we're okay with. And the whole thing about her saying, and you can see where she's going with this. She's on Team Brennan. She's not on Team Justice. I'm blaming it on the medicine. I'm not as filtered today as I usually am, trying to give her the benefit of the doubt. This is not Team Justice. Her saying, how can you prove it's exculpatory? Y'all, the whole thing was, it's like, it doesn't have to prove that you're like, for that video to be exculpatory, it doesn't have to show like a close-up of the taillight in, perfect condition, or we know it's not perfect condition, where it's just cracked instead of, shattered. It doesn't have to show that for it to be exculpatory. The whole thing about exculpatory is, and Brennan even put this in the motion, the whole thing about exculpatory is it's something that is going to help the defense's case. This helps the defense's case because it could potentially show the, tail light, whatever else they have that we haven't seen that is, it's raining, video clips of Sallyport videos, but whatever. We don't even know what else they have. But regardless of what they have, it shows that when Proctor said, I was not by there, or when they said that, like the timeline, about how the timeline was wrong and they didn't, they wouldn't have had time. All of those things, this video shows that that's not true. They did have time. Now, does that mean that it had to have happened? That this proves that they planted taillight? No, but it doesn't have to prove that that anything happened in that sense in order for it to be considered exculpatory. Exculpatory evidence is a very broad umbrella for a very good reason. This goes directly toward the credibility, as if he had any, but it goes to the credibility of, Proctor lying about stuff, but also they withheld all this. Why, and then the whole thing with Proctor talking to the federal grand jury about how he's seen all of this video, but he hadn't seen it in a while. So they didn't find out about the video about this other video until watching or reading Proctor's transcripts from the federal grand jury. How is that a thing? How is that a thing? Karen Reed does not have to prove she's innocent. She doesn't. You're absolutely right, but Brennan is running this like a defense case and keeps shifting all of the burden to the defense. Yeah, I just re-listened to Jackson's argument. She does not want to grant she does not want an evidentiary hearing. She does not want any of them to have to get up here and explain any of this. She's so hypocritical, analyzes every word from the defense, but accepts vague hearsay from the and that's part of the biggest problem here, is that every single thing that is said and done by the defense is put under such a critical and criticizing microscope. But Brennan can get up there and with all of his vague innuendos and his theatrics, and that's just taken at his word. Exculpatory is anything that the defense can use in their case strategy, and it is broad for a reason. This is specifically stuff that they can use, and it goes toward their theory. Yeah, unfortunately, being under oath won't stop them from lying. They already lied during the first trial. Yeah. And it's not going to stop. And okay, so now we hear for the first time, Buchanan is admitting for the first time that in May of last year, he was provided with a thumb drive and a CD labeled with a Post-it note to review for testimony, and it included the Canton PD exterior Sallyport. So they had it in their possession. They knew about it, and they reviewed it before trial, but still didn't turn it over to the defense. I predict a higher court appeal to have Judge Cannoni recused. Blatant differences in standards of evidence between parties. It's so blatant. So blatant. So Aiden charge looks new, as in it happened today, filed in Stoughton. I don't know what he did. Oh, is this the one that they said for his theme song? Look, that's another thing. They have they're handing out felony witness intimidation charges for people leaving rubber ducks on a sidewalk, but nobody has anything to say about these people who are handing out the ARCA witnesses, emails and telling people to email them and posting pictures of their, families, like Dr. Wolf's wife and children online. like, demanding people write into ARCA and have them fired for their testimony. That's not intimidation, felony intimidation of a witness. That's literally trying to intimidate and bully federal witnesses, or witnesses that were hired by the feds, I should say, because of their testimony, because of their reports, because of their findings. That's cool. But if you put a rubber duck on the sidewalk in Canton, then you're going to get a felony. Do we not understand? Like, do we see how? Is this thing on? Like, are we, y'all? I can't. They are so focused on all the wrong things. And Brennan's a hypocrite. That is my opinion. It's a very strong opinion. But I feel like he's a hypocrite because he gets up there and does his whole thing about how the witnesses, deserve to be able to testify without getting, harassed or bullied. And I agree. But bruh, that also goes for the ARCA witnesses. That also goes for, like, people who aren't on your, I was about to say on your payroll, but it's not just the people on his payroll. He's such a hypocrite. Speaking of hypocrite, so when I was doing all of these the other night, I used his own words against him when I was making some of these. The Commonwealth presented inverted Sallyport video to the jury as true and accurate. They don't tell the jury that it's inverted. Shh, don't tell them. Then Buchanan says, as you can see in the video, no law enforcement officer approached the right rear taillight. They made it look like Proctor was standing by the left rear taillight, when in fact he was actually standing by the right rear taillight. Pretty important stuff in this case. And then, of course, the Commonwealth was ordered to turn over the videos and metadata. They said that they did. It's now 2025, and they are still turning over exculpatory video footage that the defense didn't have in the first trial. That would have been nice to have. So, people on X criticizing the ARCA witnesses blows my mind. Well, yes, and I agree, and I will tell you, I understand it. The reason that I understand it is not because it makes sense, logically. But the reason that I understand it is because the people who are criticizing them are the people who need for them to not be taken as seriously as they are. In order for these people to be right, because this is a bunch of right fighters, the ones that are criticizing them are not people who have, like, brains. These are right fighters. So in order to try to discredit them, you can't discredit, like, their report was made, the findings of their report about how the car didn't hit John O'Keefe and John O'Keefe was not hit by the car, that was read in open court March 12th before anybody had ever contacted with them. Bottom line, nothing changes that. But people like to, take one little piece, and Brennan knows that, and he's inciting the riots on purpose. Like, he's doing this on purpose. That is my opinion. And you can't convince me otherwise at this point. But people need to believe that ARCA isn't as reliable as they are, because people want to be right. So that's when the personal attacks come in. If you have strong arguments on your side, if you have truth and physics on your side, you don't need to go to personal attacks to try to discredit somebody else so that people take you more seriously. it just doesn't happen. And the people, you look at like the work that ARC has done and the, you know, entities that hire them and that trust them, it's obvious that they're reliable. The U.S. military, the federal government, local, state government, local and state, I said local, state, local and state, local, you know, government entities as well, National Hockey League, NASA, SpaceX, like among a bazillion others. They're like, some troll on Twitter is not going to all of a sudden wipe out the credibility of ARCA, but people want that to happen so that they can have an argument to explain, because that was something people couldn't explain. No matter how much the right fighters want to be, you know, like want to explain anything. Like I don't care if, you know, who thinks what about guilt or innocence. Like people can see things that, you know, different ways, and I get that. But one of the main things that people couldn't explain was the crash daddies. So they would make stuff up about how like, oh, well, it was only on very limited stuff that the defense gave them, which is not true. Like this isn't like the defense only told them one or two little things and they went and do this. Like they got their information. Like it was like the, you know, autopsy and the pictures and stuff like that. That's not stuff that the defense is like, that's actual information that's, you know, being given to do this testing. And it's hard to see people that are trying to tear down that part of it based on something that was misrepresented in court. So it's, you know, it's desperate. Yeah. It's desperate. Like to pretend like it's, you know, to pretend like they were paid for, you know, to write up whatever kind of testimony or report that the defense wanted. It's just not possible. It's just not true. It's not possible. The defense report was written, or the ARCA report was written before the defense ever spoke to any of them, and they got the report at the same time. Do you think that the ARCA witnesses would want to alter their report and then have to go explain to the feds why they altered their report? No. Use common sense. Use common sense. But some people want or need that to be the case so that they can explain away the science and the physics. Randy, they only said it could not happen by just hitting the arm or head alone. They said a lot more than that. They said a lot more than that. I just like me sick feeling. I feel for Karen and so sad for the O'Keefe family that they won't get justice for a while. The truth will come out. And God, I hate that everything is handled the way that it was, because think about it, things would have been done the right way. Like, you know, there wouldn't be such a media field day around this. The defense should have come clean about talking to them and paying them, though. Yeah, I mean, talking to them is one thing, like because they did say that in the hearings. You know, they did say that they had talked to them about background and coordinating testimony, were the two exact things that he said he talked to him about, and that was what was in the emails. That was, you know, what was offered. Them having the emails where, you know, they tried to hire them like you would do. That's the normal process you would go through as a defense attorney. You see an expert who's, you know, who you want, you try to retain them. You know, he put as required because they don't know what's required. Obviously, everything was put on pause because this is such a weird situation. It's like new territory for everybody involved. So they couldn't. So nothing else happened after that. Now, the invoice and all of that, they did disclose that for this trial's testimony. The only discovery violation that they really have for the last trial on that is not sending over those emails that were sent. I mean, not even a day before. It was less than 24 hours. He sent it, Dr. Wolf wrote that out and sent it Sunday afternoon, and he was on the stand Monday morning. So that should have been sent. But with Alessi, pointing out that all of that stuff that was in there was still in the report, and obviously going by Jackson's questions that he asked, and then the report, you can tell that he didn't use it. So as far as like the prejudice that exists for it, it's not really nothing like the prejudice that exists for the withholding Sallyport videos. But regardless, that should have been done, and it wasn't. But like Bev keeps saying, like Brennan keeps saying, that was the last trial. This trial is different. So what they'll do is they'll use it on this trial's cross-examination. They'll say, were you paid, and the defense didn't. It's still very, because words matter, it's still very specific about they were not paid by the defense to do their testing. They were not paid by the defense to do their report. All of that stuff came before, the defense brought them in to testify. So all of that will be used for cross-examination this time. The physics support him being hit by the SUV. The kinetic energy made it possible. I have re-listened to both experts. If there's anybody that has listened to that testimony, between all the episodes I've done on all of that, I've re-listened plenty. But yeah, that's not, we'll have to agree to disagree on the findings on that. That is a big stretch on what was actually said. And I am going by what they actually said, not like, spins on it. Did I hear the prosecution sent the defense 400 pages of new discovery? Yeah, they just did some more discovery drops recently. We'll see exactly what all it was. Even the Commonwealth's pathology said that John O'Keefe's injuries were not consistent with a car strike. Yeah, all of them said that. And that's the thing is, like, there's one little clip that people clip from Dr. Rentschler where they do that thing where they cut out the full context of it, where he says that that it would be possible. I can't remember exactly how it is that they're clipping it, but whatever part it is, it's like that it would have been possible for him to hit his head by falling or whatever. And he goes into this kind of explanation that he's like, first of all, like he didn't travel far enough. Like the way that the Commonwealth is saying that it happened couldn't have happened. But even if, if the situation would have been right, he could have fallen and hit his head. Sure, that is, falling and hitting your head on something is one of many, many possibilities on where the head injury came from. But remember, their fourth opinion that they were not allowed to give in the testimony was about there not being enough evidence to really be able to tell what the head injury came from. But they weren't allowed to talk about that part because they're not medical doctors. Alrighty. O'Keefe's elbow would have been broken in several places if his elbow would have shattered. Yeah, that's one of the things that people all said about all the pathologists, medical examiners, all that were saying, no bruising and no, broken bones. That was one of the things that Crash Daddy said too, is that the, elbow and all of this, like being a hinge, the arm is on a hinge. So it's not possible to do things the way that they said. Do you think that Brennan seriously thought he could get a weatherman to testify about the hardness of the ground? Yeah, I do. I think he was hoping to get it in there, which is, okay. He tried. That's going to be an easy, I missed a lot of yesterday because I haven't gone back to watch it since I told you I kind of had doctor, and then I was in and out with pain medicine. But I remember, I think I woke up at one point where they were talking about that, but I'm assuming, I don't know, I'm assuming she hasn't ruled on the bench because she never does, but that should be a very easy, like, not eliciting that testimony solution. Because I mean, that's just simple law. You can't. So that goes back to the Cara Rentala, the fresh paint, Wouldn't the hardness of the ground work against the prosecution, i.e. he fell and hit his head as opposed to being hit by the SUV? I don't think that they have tried to say that his head was hit by the SUV, because I know that was one of the things that Lally got kind of his, panties in a bunch last time, because he thought that the ARCA experts were there to try to testify about his head being hit by the car. It's one of, multiple options that they looked at, but they weren't given that specific. So I don't think that they, and that's one of the things that I think it was Dr. Rentschler that was explaining that too, is like, yeah, the, curb or berm, whatever it's called. Is it berm? We call it curb. Whatever it is. He, could he have hit his head on that? Yes. But based on what the prosecution is saying, they're not saying that he hit his head on that. They're saying that he went out into the ground. So that's, two different parts of the ground. But that's a whole nother thing about them not being, not exact's not the right word, not being firm in their theories. It's all kind of like, well, maybe this could happen, maybe this could happen, maybe this could happen. We'll see. Oh, he hit the front of his head on the back of the SUV. Okay. Facts, not in evidence. That's not what. But okay. Was it snowing? I don't think they mentioned it all. There's going to be a meteorologist to be able to answer those burning questions for all of us. The fact that there is still disagreements over whether she hit him or not means there is way too much reasonable doubt for a conviction. That's my thing. That's what I say. I say over and over, I don't know what happened. I am not going to jump on the train of this person or this person or this person. I have my own theories. But obviously y'all know I don't share those publicly because I don't want to, I don't have enough evidence to really feel comfortable accusing anybody of anything. But the fact that there's not enough for me to know fully and be, fully convinced of anything, that itself is reasonable doubt. If it could have been this or this or this, that's a not guilty. I don't understand why John Keefe was trying so hard to be friends with them. Well, think about it like this. Like, if, you know, if it's somebody that you... Lucy's snoring. If it's somebody that you, you know, really admire at work, you know, and, you know, maybe... you know, because we all look at the stuff that they do and say, and we can be like, I can't say that, you know, any of them are guilty of anything, but I can say that a lot of them are not very likable. That's my own personal opinion. But even the two of them that troll me on Twitter, and I don't think they know that I know who they are. Or maybe they do. I don't know. But anyway, the two of them that troll me on Twitter, not very likable. I see y'all. Little B, thank you so much for Lucy Snacks. She's down there snoring right now. She's getting louder and louder as she snores. But it's really cute. Like, she's super loud. You hear that? See if I can get the microphone down there to her without waking her up. Oh, I woke her up. Sorry, Luce. I was just trying to spy on you and let everybody hear the fact that you snore like an old man. It's fine. Go back to sleep. Court should be back in about 10 minutes. I've got it pulled up so that we can watch when they come back. Hello. Hey there, Brady and chat, popping in to hit the like button and say hi. Hello, I'm glad you did. Regina, thank you so much. Some more Lucy Snacks. Oh, she's... Do you want a snack? Do you want a snack? Oh, you sent the link to my DM. Okay, yes. Let's see where we're at with this. We're going to vote for... All right. I'm going to put it in here. This is for Candace Hoff for America's Favorite Teacher. All right, here, we're going to do it like this. We're going to pay, everybody go vote. It'll let me vote 25 times if I pay $25. Making me do a code. This is for Teacher of the Year. There's 32 hours left. Okay. I just put the thing in there. So everybody go vote. That's our very own mod extraordinaire. Trying to get America's favorite teacher. I just did 25 votes. We got 1 day and 8 hours left. And she's currently 6th place. So everybody go vote. You don't have to pay to vote. You don't have to do that. I just did that so we could do extra because she deserves extra. But there, you can vote for free on there. So everybody click that link and vote. Yes. She's currently 6th. We're going to try to get you up there. Yes, voted. Yes. Yep, you get a free vote. We're going to check it again. Currently 6th. Woo! We're going to get you first. All right. So they should be coming back in just a couple minutes. Let me grab Lucy a snack since y'all all voted for her to get a snack. Oh, we love you. All right, I'm going to get her a snack. I'm going to leave this right here so that if they come back before I get... And I'm going to get myself a snack too, actually. Snack sounds good. Oh, I think they're coming back. All right, I'll be right back. See, perfect timing. Stop pressing buttons, Brandy. There we go. Okay. Calm down. Lucy's eating her snack. And I've got me a snack. We're going to get ready for it. It's a cupcake. Oh, Melanie Little would love it. And hopefully, the sweetness will make me be a little less salty. Okay. Lucy loves her sisters. They're really cute together. She's still, even with them being as big as they are, she's still in charge, you know, little diva. But it's cute. Sweet and salty are a good mix, yes. Good point. I see, it looks like there's a lot of people very angry about how Judge Cannoni is acting. All right, let's see. The hearing is going to continue. Oh, I didn't put my timestamps. Sorry, I'll go back and do those. The hearing is going to continue for the motion to dismiss. He said he's got about 45 more minutes. Then we'll hear from, oh, camera's moving. Then we'll hear from Brennan about it. And then, did she say yesterday if we're going to do their argument over Wolf today? The other Wolf? That's what I just heard too. That there's another charge being added to Turtle Boy, I guess. Somebody said that it was over the intro song. And I was like, that couldn't possibly be true. But it's Canton. Let me pull it up. Let's see. He says the Commonwealth, this is from Turtle Boy. The Commonwealth finally filed a response to our motion to dismiss. Cosgrove claims I make money by begging online for contributions. and flat out lies about getting stuff by cheating, I'm gonna fuck you up.
All right, Mr. Jackson, go ahead and continue.
Thank you, Your Honor. When we left off before lunch, we were discussing the inverted video. In the moving papers, the prosecution indicates that, quote, the prosecutor had not previously received this video or knew of its existence. This is I don't know, it's the third or the fourth time that the Commonwealth sort of runs to this argument about not knowing personally about the existence of a particular video, but that it doesn't matter how many times they argue that point, it still doesn't change the fact that it prejudiced the defense by not having it, and one of their members, whoever that agent is of the Commonwealth, was lying about having it and not disclosing it. Somebody knew, and the question before the court is, who was it? Who did know? Perhaps it wasn't Mr. Lally, perhaps it wasn't Ms. McLaughlin. Was it Chief Rafferty? Certainly Proctor had it. He watched it. Who else knew about it? Members of the prosecution knew of the existence of this and other videos, and they hid them, and that's the galling issue. Then the Commonwealth writes that the defense altered, their word, the defense, quote, altered evidence to correct the image, as if we were altering something to deceive the court. When in point of fact, the Commonwealth well knows that that altered video was altered by them in some way, shape, form, or fashion. When it was played inverted. What we did is recorrect it to the proper orientation to confront Sergeant Buchnick with it. They indicate that they played the entirety of the video, of the corrected video, to somehow suggest that the Commonwealth, during this debacle, had clean hands. And that's just not true. Over the course of 2 days, the court will recall 2 days worth of testimony. Day one with Sergeant Buchnick under direct examination by Mr. Lally. Going into the next day, still under direct examination by Mr. Lally, they played that video completely inverted. They talked about it, they discussed it, they described it. Not once did Sergeant Buchanan or Mr. Lally inform the jurors or the court that the video was actually altered, that the video was actually backward. Not one hint to the court or the jury members. When the defense stood up and began questioning Sergeant Buchanan about that video, that was the first time that he admitted that it was inverted. He used the phrase mirror image, and that he knew that it was inverted. Amazingly, that was the same time that Sergeant Buchanan started having trouble with his memory about who was actually depicted in that video. The court will recall before I stood up on cross-examination, under direct examination by Mr. Lally, Sergeant Buchanan was very quick to point out that the individuals on that inverted video were himself and Michael Proctor. And they made the point that Michael Proctor never approached or had any access to or didn't manipulate in some way, shape, form, or fashion. This was the intimation by the Commonwealth, that passenger taillight. The Commonwealth has now conceded that that person was, in fact, Michael Proctor. It's notable that the Commonwealth went to great lengths to state that, quote, Trooper Proctor, and this is in their opposition, Trooper Proctor is standing feet away from the defendant's vehicle and never touched the right rear taillight, end quote. That's a statement made in their moving papers, specifically on a fact that is of great material importance to this case. The three of them signed, the three prosecutors signed an oath and a declaration, and the court just called the defense out on signing a declaration or an oath, and the court's intimation, at least, in its initial comments to me was, you may have said something that you don't have a factual foundation for. I think I have done my best to disabuse the court of that we were drawing from reasonable inferences. I wonder if the Commonwealth is going to get the same treatment for saying that Trooper Proctor was standing feet away from the defendant's vehicle and never touched the right rear taillight. That's a very bold statement for the Commonwealth to make, and it's also completely untrue. It's not supported by a single fact. It's not supported by a fact or evidence before the court. The problem with this unsupported motion, because it's unsupported and the declaration is signed by 3 different individuals, you can just sort of say whatever you want in the motion. And I guess get away with it. The video speaks for itself, Your Honor. It shows Michael Proctor walk behind the car directly to the position of the passenger taillight. He positions himself right on the other side of the camera view, not feet away. And it certainly does not show, and there's no evidence before the court, that he, quote, never touched it. As a matter of fact, we would submit...
Does it show that he does touch it?
Well, of course it doesn't show he touches it, Your Honor. He's on the other side of the car. That's not the point. The point is, a reasonable inference is he could have touched it. He was standing right there. Nobody forced him. Nobody was holding a gun to his head. He walked around the other side of the car and obviously was standing there for a reason. By himself, in a corner, out of the view of a camera, and then when the Commonwealth plays the video, it switched, and the intimation to the triers of fact was he never approached the right rear taillight, that passenger taillight. And all of that
And
was
you
unclear.
cleared that up.
Right. But that is the galling part of this entire thing. The court has asked me a couple of times, and I'm going to get to it a little bit more in detail, what the prejudice is. If that's not prejudice, I don't know what is. It's literally propounding false information to a trier of fact. That is not a small thing. Even after the trial was over, it was concluded, and the mistrial was declared, we're still getting videos that we can't get a straight answer about their source. Where did these videos come from in October? That surveillance feed is on a 30-day deletion loop. That's what we've been told. I said a few minutes ago this morning, I said the Commonwealth may not have known that it was on a 30-day loop. What I meant was actually the prosecutor sitting in this courtroom. The 3, my brothers and sister, may not have known about that 30-day override. I don't know. I don't know what they knew or didn't know. I'm certainly not going to cast aspersions and put that on them. But someone from the Commonwealth darn sure knew that was on a 30-day loop or a 30-day override. So who's had those for all this time? How were they stored? Why wasn't that information revealed to our expert when we went all the way to Canton to try to download that DVR? Where's the original? Where are the copies? These are questions for which we need some facts. And the fact that those have been withheld from us is exactly the kind of bad act and bad faith that demands that the court presume prejudice in the case. A few minutes ago, the court asked me before lunch, what is the prejudice? There's plenty of actual prejudice, but I'll get to that in just a second when I speak a little bit about the law at the end of my comments. We don't need to prove actual prejudice because the law presumes prejudice against Ms. Reed because of the bad conduct on behalf of the Commonwealth. And yet again, when it comes to this same issue, the Commonwealth recites this now worn out sentence, the prosecutor was unaware of the existence of these videos, end quote. How many times are they going to try to excuse away a blatant discovery and or Brady violation with the sentence that the prosecutor was unaware? It just doesn't matter. And that brings us to the October 10 videos that we got in 2024. The Commonwealth claims that they received these videos on or about August 21st, 2024. They sort of vaguely claim that these videos were provided along with a letter, quote unquote, letter from Canton Police Chief, end quote. There's no report, there's no email, there's no communications, there's no text message, nothing other than this, quote, letter. And it actually wasn't a letter, it was more of an informal note written on a personal pad, a Canton PD pad by the chief. There's no chain of custody log authenticating the videos, no authentication documents whatsoever, no foundational documents, no indication of where the videos came from or how she came to possess them at the time. But she did write on that little pad, quote, that is how it records, LOL, no tampering, end quote. LOL. Laugh out loud. So the chief of police is laughing in the face of serious Brady violations, in the face of serious evidentiary violations and
And what was the
discovery
date?
violations.
10/10/24 you received that? Was that the date?
10/10/24. That's correct. By the way, the Commonwealth claimed in its opposition papers that, quote, the prosecutor requested that both Massachusetts State Police and Canton Police Department produce all relevant and material surveillance video, end quote. And that was sometime unidentified between April 17th, 2024 and April 24th, 2024. I laud them for that. Good. I'm glad they demanded finally, in the middle of trial, quote, all relevant and material surveillance video. So why didn't we get this from Canton PD until October 2024, well after trial? What was the delay? And why did we get another video in January of 2025? What was the delay? How could this be seen as anything other than intentional? We know now that Sergeant Buchanan, we know that Proctor, we know that Chief Rafferty, and now through another report, we know that this officer, DGM Petro, all had access to and knew about the videos. And then we have on top of that, in the middle of trial, I think it was Mr. Lally, it may have been Ms. McLaughlin, someone said, it's unclear from the opposition, that all relevant and material surveillance video be turned over immediately, and it still wasn't done. That is an intentional withholding of evidence. And then we get these new reports. What's probably most troubling is what's in the reports that we got on Friday, this past Friday. Additional reports from the Commonwealth in a report from Sergeant DGM Petro. He reveals the following. He writes this report on the 27th, which was last Thursday, and then we got the report on the 28th. He says that in February of 2022, and I'm paraphrasing, in February of 2022, Proctor requested Sallyport video of SUV inside Sallyport. Apparently that was provided. I mean, we have to presume from his report when he says Proctor requested in February of 2022 Sallyport video of the SUV exterior footage that he downloaded it from somewhere and gave it to him. Assuming it was February of 2022, that would have been before the override, I presume, because I think the math in my head is it's 28 days in February. If it's in February at all, it's within the 30 days from January 29th, so it has to have been. Then he writes that in June of 2023, Proctor requested Sallyport video again of the SUV exterior footage. Quote, this is from his report, I believe this may also have been the approximate time that I downloaded video recordings that covered the entire time frame that the suspect's vehicle was held at the Canton police station, end quote. He goes on to say, quote, due to the large size of the files at that time, I had to break it down into 6-hour blocks for ease of exporting. This is the first we're hearing of any of this last Thursday. How is that? Sure. Ms. Looms just handed me a clean copy of the DGM Petro report. I would like to have this marked and appended to our motion to dismiss if it's okay.
Sure. Did I get that attached to your motion to change the scheduling?
Yes.
You probably did.
So I've seen it.
Okay. May I approach?
Hold on. What, Ms. Little?
We'd still like to make it part of the record if that's
Sure.
all right, Your Honor.
Sure. I just wanted to know whether I needed a copy because I have a copy. I've seen it.
May I approach?
Yes.
So he downloaded videos of the entire time.
So are we marking it? So we need it if we're marking it.
You got to mock it.
I'm
You got
sorry.
to mock it.
My mistake.
Exhibit 1 so marked?
Okay. Go ahead, Mr. Jackson.
Thank you, Your Honor.
This is crazy.
The question is, how in June of 2023, now I'm going to go a little bit slow here just because it's linear. The argument is linear. In June of 2023, according to DGM he downloaded every single bit of video of that car while in the Sallyport or while at Canton PD in Sallyport. How is that possible? How could that be? As of February 28th or maybe March 1st, those videos are gone. So how could he have access to the whole thing? It's because someone at the Commonwealth downloaded the whole thing. They saved it. Or the only other explanation is that DVR was not at the time on a 30-day override. It's the only two explanations. Again, this is binary. So in April of 2024, as the court knows, we got additional video, and that's the inverted video. In the spring of 2024, while trial was being held, DGM quote, it says, quote, I downloaded some video recordings that you and I believed may be needed to refute claims being made by the defense. The you and I is him to Chief Rafferty. That's who this report is to. And it includes footage of Higgins. So now we find out, for the first time, that Chief Rafferty and this sergeant had been talking and strategizing about how to defeat some defense arguments, presumably, by use of videos that had never been turned over. And the Commonwealth uses a phrase in its moving papers, I believe in this motion, about ambush. That is the definition of an ambush. So DGM Petro admits that he, Rafferty, and the Canton Police Department had Sallyport video that was material to the case. Remember, his quote was that you and I believed may be needed to refute claims made by the defense. They were strategizing about how to defeat certain of our arguments, and they didn't turn it over.
Wow.
Specifically, he downloaded video and presumably gave it to Chief Rafferty. But then the interesting thing is Chief Rafferty held on to it. She never turned it over. Probably because they didn't help the prosecution. They showed Higgins engaged in conduct that is, at the very least, highly suspicious and clearly exculpatory because it impeaches his other testimony. It shows him on the phone. And he testified that he didn't make calls in the middle of the night. There's no question that with this example, that is an intentional withholding of evidence. That is the legal definition of bad faith, and it's unconscionable to do that. Now put in context what we eventually did receive during the trial and then after. We received the inverted video that was falsely presented as the right passenger side of the vehicle, or the passenger rear side of the vehicle. Number two, we received several videos of Brian Higgins at Canton Police Department, clearly using his phone at approximately 1:35 or so a.m. And we received exterior footage that would ordinarily show the condition of the passenger taillight, which all happens to be corrupted, like every other video of the rear passenger side of that SUV. This is stunning. It's not like the Canton Police Department and the Massachusetts State Police were sort of blissfully incompetent or blissfully ignorant and unaware of the existence of these exculpatory videos. It's quite the opposite. Multiple officers, Proctor, Rafferty, Buchnick, O'Rourke, DG and Petro, these individuals, we believe, O'Rourke may not have known, but we know that the others did, and have now basically admitted it or been caught trying to hide it. They were all variously actively engaged with these videos. They were searched for, they were discussed, they downloaded them, they saved them, they copied them, they labeled them, they transported them, they reviewed them, and they strategized about them. These videos were top of mind for all of these folks. We know there were hours and hours and hours of footage that was so large it had to be broken down into 6-hour blocks all of that was pulled. And none of this footage was disclosed to the defense before April of 2024. And most of the files that have been turned over so far have been turned over after the trial was over. We had no idea this footage existed, and to this day, it continues to be, the bulk of it continues to be withheld from the defense.
It's wild.
And then we move to Sergeant Buchanan's actual report. As I indicated, he wrote a report last Friday as well, dated the 28th. Quote, in furtherance of the John O'Keefe Canton homicide investigation, sometime in early spring of 2022, I was made aware that a request had been made by Trooper Proctor and then fulfilled by Canton PD for surveillance video as it related to the arrival and storage of the Lexus SUV belonging to Karen Reed. This was the spring of 2022. He knew. At Trooper Proctor's request, I proceeded to Canton Police and picked up the digital media storage containing said video and transported it to the Canton, Norfolk District Attorney's Office and turned it over to Trooper Proctor. I did not review this video at this time.
What date did he do that? The same date?
He says at this time, but it's the sometime early spring of 2022. That's the best he can do in his report. Paragraph 2. In July of 2023, so this is a little more defined, I was once again made aware by Trooper Proctor that a request had been made to Canton PD for additional video and that it was ready to be picked up. Since the Canton Police Department is conveniently located on my route of travel to work, I stopped by and picked up the CD from the front desk of the police department, which was labeled Trooper Buchanan with a yellow Post-it note. I further added Canton PD 12922 and then the case number, which is, or their case number, 2022-112-33, to note to more accurately identify the item and transported it to our office, subsequently turning it over to Trooper Proctor. So there's a second CD, now in July of 2023. I did not review that video at that time. See the attached copy of the Post-it note. Final paragraph, in my preparation for trial in May of 2024, I was provided with a thumb drive and the CD labeled with a Post-it note on my desk. What's interesting is that the CD with the Post-it note on his desk may or may not have been the same CD that he transported in July of 23 because they seem to be labeled a little differently.
So I haven't seen this report. Does he say from whom he received that?
I'll finish reading it, but I don't believe he does. No, it's pretty vague. It's passive voice and it's pretty vague. I was provided a thumb drive and a CD labeled with a Post-it on my desk to review prior to testimony, so it does not say. At this time, I reviewed video made available to me, which included video footage of the Canton PD exterior Sallyport. This video was labeled with a Post-it note on a CD, and it contained a video of the interior of the Sallyport, which was grainy and had a camera vantage point from the front of the Sallyport. I also reviewed the Canton PD driveway footage. In review, I also viewed video of the back wall Sallyport camera vantage point. I had not seen this video prior to my May date review. I later learned that this video was provided in an inverted manner. After I reviewed all the provided video, the thumb drive and the CD were returned. It doesn't say to whom they were returned. Your Honor, if I could mark this report as well.
Sure. Do you have an extra copy for me?
I do. It does have one highlight on it. May I show it to Mr. Brennan?
Yes.
Okay.
Are the two still marked?
So you do have an extra copy, Ms. Little?
I do not have an extra copy, Your Honor.
I thought Mr. Jackson just said he had an extra.
Oh, I'm sorry.
Yeah. Mr. Jackson, do you have an extra copy?
I think I might.
I've got it right here.
You have an extra copy? Is that one clean?
Not clean.
Hang on a second. No, that was the only copy that I've got.
May I approach your
Please.
This one has highlights on it, I apologize.
It's okay. Thank you. All right, go ahead.
Thank you, Your Honor. The court asked probably the most important question about this report, which is, who was it that supplied the video or the thumb drives or the CDs to Sergeant Buchanan? Who's at the center of all these Sallyport videos? Who does he say was requesting the Sallyport videos that he was acting as the courier for in other particulars? Every one of those answers is Michael Proctor. So who do we believe most reasonably would have supplied the information to Sergeant Buchanan to review? It stands to reason it could have been Trooper Proctor. Seems to be reasonable. But I don't know because Trooper Buchanan doesn't say, but that would be another question that would be open to answer if we had an evidentiary hearing. Michael Proctor was receiving the footage directly from DG Petro, dating all the way back to February of 2022. He was the one receiving the footage directly from Buchanan, dating all the way back to the spring of 2022. Michael Proctor was receiving footage from both sources multiple times through the years. Proctor was the one who clearly had possession, custody, and control over the exculpatory footage. It was his, every bit of it. And now let's recall what he said at trial when asked about all this footage, because he was confronted about footage. And keep in mind, Your Honor, when I'm asking these questions, I know none of this. None of it. Michael Proctor lied during his testimony, but he knew that we couldn't impeach him. There was no way I could impeach him. I didn't have any of these videos to impeach him with, because we didn't have any of the evidence that had been secured concerning that Sallyport. Question. There's surveillance video from Canton Police Department's Sallyport garage that wasn't turned over, right? Answer. That video was discovered later on and then handed over. That video was discovered later on.
So where in the transcript is that?
I can get you the page and line number, Your Honor.
My guess is Ms. Little can get it pretty quickly.
I'm guessing she
I'll provide that to you
can.
in just a moment, Your Honor.
June 10th?
It was either June 10th or June 12th, but let me double check.
While she's looking for that, Your Honor, may I proceed?
Please go ahead, yeah.
Okay. The only thing that's it's important to remember from a date standpoint, we'll get the date that he actually testified to this, but from a date standpoint, the only thing that had been handed over at the time that he testified to that was a single video with 42 minutes missing and a flatbed and the flatbed driveway footage outside the Sallyport that doesn't show much of anything. It's now been proven, that testimony, that video was discovered later on and then handed over, suggesting there was either only one video or all of it was discovered later and turned over. Both of the clauses in that sentence are a lie. The video wasn't discovered later. It was discovered in February, at the latest, February of 2022, just days after this incident. He asked for it, and he received it, according to Sergeant DG Petro. And it wasn't turned over either. None of it. But at trial, we didn't have the truth. I couldn't impeach him with this. He made sure that all the footage was delivered directly to him, starting days after this incident. And he controlled it, he hid it, and then he lied about it. That is the definition of bad faith. That is the definition of withholding exculpatory evidence. That is a definition of suppressing Brady evidence. There is no other way to define this. He fooled us, and it's egregious. Is it possible with all this sort of years-long flurry that we've just talked about surrounding Sallyport videos that the actual trial prosecutors were completely unaware of their existence until Proctor testified before the federal grand jury. Is that possible? I suppose it is. I want to give the prosecutors the benefit of the doubt. I do. Is it reasonable? That's another question. To believe that they just knew nothing about this. We know Proctor lied to us. Could he have lied to them? I suppose. But as the law mandates, Your Honor, it just doesn't matter. In the eyes of the law, Proctor is the prosecution, and the prosecution is Michael Proctor.
That's important.
And then we move to January 28th, 2025, this year. We're still getting additional videos at that time. This new camera angle, which is blurry and grainy and wobbly, it does, however, show the passenger side rear taillight as it's towed into or driven into the Sallyport garage. The footage is so grainy and so blurry, however, it's so corrupted that once again, the true condition of that taillight is completely obscured. At a certain point, it begins to defy logic. And the reason I wanted to talk about each one of these videos in turn is because it absolutely defies logic that all of this footage magically cuts out, blurs out, becomes grainy, becomes obscured at the precise time that the SUV is pulled in to the Sallyport. The question then becomes, what's been happening to these videos that have been in Michael Proctor's possession since that time, for the last 2.5, 3 years? And again, I've lost count how many times the Commonwealth makes the claim, quote, prosecutors had never seen this video, end quote. The entirety of the Commonwealth's defense on this issue is the indefensible, which is, it just wasn't me. Okay, fine, it may not have been you, but it was the Commonwealth, in quotation marks, capital. The Commonwealth then claims that, quote, after directing a review of all physical evidence and data files, after directing a review of all physical evidence and data files, this video was located within a paper case file of the investigators, end quote. I believe that Mr. Brennan, when he came on the case, he's the one who directed a review of all physical evidence and data files. I would have to guess. Again, I would applaud that. Should have happened years ago. What's most curious about this video, however, is that the prosecution now admits, quote, after inquiry it was learned that an investigator obtained this video from Canton Police Department in 2022, and it was placed in a physical case file, end quote. That's a direct quote from their opposition. They don't name who the investigator is. They don't indicate whose case file it was. They don't tell us where that case file had been, who had control over that case file, just a paper case file somewhere, mysteriously. Whether it was CPD or MSP, we don't know. Which investigator, we still don't know. What can we learn from this admission by the Commonwealth? That investigators did, in fact, download the Canton PD videos in 2022 before they were overwritten. That's the only way these videos could exist. We've talked about that. And what we don't know is where the rest of them went, and why we don't have them, and why we didn't have them for the first trial. The Commonwealth basically concedes that it is in direct violation of its discovery obligations not to have turned over these videos that were in their possession. But it makes the claim that it doesn't matter because, quote, the poor quality of the video makes it difficult for either party to benefit from the video, end quote. In its opposition, it sounds like more of a desperate argument than anything else that these cumulative, that these egregious errors don't justify the court taking any action because they claim, quote, there's no evidence of bad faith. I would take issue with that. But the quote goes on, there's no evidence of bad faith on behalf of the Commonwealth, nor any of its agents, particularly where the Commonwealth is equally aggrieved by the poor video quality and inability to obtain a forensically extracted copy of the surveillance video. Equally aggrieved. First, in that sentence, the Commonwealth admits that the defense is aggrieved. They say they're equally aggrieved, however. Aggrieved means wronged or unfairly treated or suffered harm or injustice. Merriam-Webster defines aggrieved as suffering from an infringement or a denial of legal rights. You bet we're aggrieved. But the Commonwealth can't claim that they're aggrieved when they're the ones doing the aggrieving. It doesn't work that way. The Commonwealth concedes that there's irreparable harm. They acknowledge that the forensic videos were destroyed, or at least they claim now that they're destroyed. We can never obtain the information necessary to establish the validity of any of these videos or whether and by whom they may have been manipulated, if at all. The Commonwealth can't shift the blame because the videos have literally been in their possession the entire time. It was their actions and the actions of their agents that caused this irremediable harm. Your Honor, this is, as I said, this is the definition of bad faith, and this goes back to the court's original question this morning, which is, can you describe the prejudice that Ms. Reed has suffered? And I think we've done a pretty good job of describing that throughout this argument, but the definition of bad faith means we don't have to prove actual prejudice. Prejudice is presumed under the law. If we're to believe the declarations that were submitted by ADA Lally and ADA McLaughlin and ADA Brennan, then at the very least, there is no other conclusion but that Michael Proctor and other investigators intentionally secured these videos. They withheld the evidence from us, and they withheld the evidence from the prosecution team. Let's take them at their word. Even after being explicitly instructed to turn over that evidence, that is bad faith. And how many times do they have to say, we didn't know about this? It just doesn't matter. Like I said, let's take them at their word. It doesn't absolve the Commonwealth of its obligations, and it doesn't reduce the prejudice that the defense has suffered. This was a pattern engaged in by the Massachusetts State Police, by the Canton Police Department, over and over and over again. And now we know through this new revelation that it was intentional. The prejudice the defense has suffered is legally presumed, and it's also factually proven. And thus the only remedy is dismissal. When is dismissal warranted? And this is, I'd like to talk for just a couple of seconds about the legal standards. Where there is misconduct that's so egregious, deliberate, and intentional, prejudice is to be presumed. That means that the defense is not required to show Ms. Reed suffered any actual prejudice because dismissal is necessary to prevent the repetition of this type of misconduct. And that comes to us directly from Bridgman versus District Attorney for Suffolk District at 476 Mass 298. It's a 2017 case. Even if the court does not, and this is secondary to that, even if the court does not presume the prejudice and finds that these myriad violations were somehow inadvertent or a mistake, the result of some accident or negligence, this case still has to be dismissed under the second scenario and the second prong because Ms. Reed has suffered actual prejudice by the Commonwealth's violations. We could not cross-examine these witnesses the way they should have been cross-examined at the first trial. The repeated and flagrant discovery violations were not an accident. I think we've established that at this point. They weren't a mistake. There were too many people looking at them, strategizing about them, to then say, I didn't realize their import. They were designed specifically, the fact that we weren't provided the evidence was designed specifically to obtain a strategic advantage over the defense and to get a conviction at all costs rather than to pursue the truth. There are obviously additional Brady violations and prejudices that Ms. Reed has suffered. I've detailed those in our moving papers. And I want to incorporate all of those arguments by reference here as well. But relating to the surveillance footage itself, there's no question that the Commonwealth intentionally withheld it, and they've been withholding it since January 29th, 2022. The Commonwealth can't really seriously claim, Your Honor, that 4 or 5 or however many different law enforcement officers were aware of and withheld the surveillance video or the surveillance footage, and who were supposedly specifically instructed by Adam Lally or his team back in April of 2024 to turn everything over, and it was just inadvertently withheld. This was intentional. And the Commonwealth then compounded those violations by Michael Proctor lying on the stand about his knowledge of the video footage and his turning it over to the defense. It was literally a fraud on the jury. And now, well after trial, the Commonwealth has been forced to admit that even more exculpatory evidence or surveillance evidence from January 2022 is in their possession, and it was also entirely withheld from the defense throughout this litigation and throughout their first trial. In addition to the presumptive prejudice, Your Honor, there has been actual prejudice. This was, some would say, a close case when it ended. The court recalls that. The jury was hung on some charge or charges, and the evidence suggests that they voted in her favor on others. The court needs to ask itself, what would the jury have done had they had all the evidence to which they were entitled, to which we were entitled? But they didn't. Every one of these videos was in some way compromised, even the videos that we did have. And the compromise always conveniently obscured the truth and obscured Ms. Reed's rights. This is an exculpatory fact that we should have been able to explore during the past 3 years, and certainly we should have been able to explore it at trial, but we did not have the videos. The Commonwealth did, though, and it's the cumulative effect of all these gross and repeated violations that undermines the Commonwealth's argument that this is just about a broken camera. It couldn't be further from the truth. We're to believe that all these cameras just spontaneously became defective at the exact same time. Like I said before, it defies logic. For the Commonwealth to have all this footage for a solid 3 years and hold it back from us the entire time, it makes one question what was going on with that evidence. And I have to say, in terms of lesser remedies, Your Honor, what's interesting is that the exclusion, obviously the exclusionary rule exists.
I understand that does not help the defense.
It doesn't help the defense. And I appreciate the court finishing my thought on that. It's the opposite. The only remedy that can prevent this kind of repetition, this kind of misconduct, is dismissal. That's the only remedy available. And that's what the law, and that's what justice demands. As a final thought, if the court, even in the face of all this overwhelming evidence of gross misconduct, declines to dismiss this case at this time, we would urge the court to grant us an evidentiary hearing so that we can make an actual factual record of the myriad of issues brought up here. This will give the court a much better understanding of the facts supporting dismissal, and it'll perfect the record on these critical constitutional issues. And with that, I'll submit.
Okay, so thank you. I have a question for you. So go back to the podium, please, because you may need your notes. But Ms. Little, did you find the Proctor testimony?
I did, Your Honor. It's June 12th, 2025, the reporter's transcript at 1-148. And that's from the copy of transcripts with sidebars, just for the court's reference, lines 8 through 12.
Great.
Thank you.
I have a question, Mr. Jackson, just about, so you argued, obviously, the importance of the Lexus arriving at the Canton Police Department. You argued a distinction between a cracked taillight versus a shattered taillight.
Correct.
In your pleadings, and again, you just saw, I want specifics where I can find something. On page 28, you talked at the top line, cracked, not shattered, when it arrived at the conflicted CPD on January 29, 2022. If the taillight was largely intact and only cracked rather than shattered and missing 47 pieces, as Dighton Police Officer Sergeant Barrows testified he observed earlier that day, after the Commonwealth claimed Ms. Reed had struck Mr. O'Keefe, the evidence would establish Ms. Reed's innocence and be case ending for the Commonwealth. The 47 pieces I'm having trouble finding. I just took a quick review of Sergeant Barrows' testimony yesterday upon being prepared for this. I didn't see it in there. Ms. Little, do you know where that 47 pieces is?
Yeah, the 47 pieces is not related to Sergeant Barrows' testimony.
Well, it sounds it from this, so I'm not to read it this way.
What Sergeant Barrows clearly testified to was that he observed a taillight that was cracked and not broken.
Okay, the 47 pieces, I read that to mean it was from Barrows' testimony.
No.
As Dighton Police, Barrows testified. All right, where do I find that 47 pieces?
The 47 pieces, I can get multiple transcript sites, but those were the photographs the Commonwealth presented at trial. that there were that many pieces found at the crime scene.
It's the number of pieces that were booked into evidence.
Okay,
Yeah.
great. Yeah, if you have child transcript of that, I don't need 47 points, but if there's something that summarizes it, because I took that to read as I see it reading.
No, Sergeant Barrows specifically testified about his observations of the taillight earlier that day.
Right.
It was uncontroverted that there were 47 pieces of taillight recovered at the
That's not clear to me the way this is written, so I'm glad I asked you. Okay. All right, so with that, now, Ms. Giannetti, I'm not going to hear from you now about the court officers not being in charge of the jury. I'm going to hear from Mr. Brennan, and then we'll get to you, and hopefully we'll have time. But Mr. Brennan, I have a question for you. As I started with a question for the defense, so I'd like you to explain to the court, please, what efforts the Commonwealth made to comply with the Rule 14 obligation regarding the Sallyport videos, and why the dribs and drabs of the way the discovery came in.
It may be most helpful if I give the court a history as I've learned it about the production of video in this case.
Okay.
And it will explain in context the production of video and will help create the foundation so the court can understand and perhaps the defense can best understand.
All right, and just like I did with Mr. Jackson, if I need to, I'm going to interrupt you
Of course.
to clarify some of this. So know that that's what I'm focused on.
I understand clearly. In November of 2024, the defense asked me to see if I could provide a chain of custody regarding the production of video in this case. And so I agreed that I would do that and made best efforts to talk to as many witnesses as I could, review the discovery, and speak to the attorneys. Now, when I started sometime in late September, I had found the letter from Chief Rafferty with the production of video in August. The letter or note was dated in August. So to start from the beginning, the prosecutors in this case did not have knowledge that there was videos from the Sallyport area. There was nothing about it that was particularly relevant to them. The defense theory
That's
did
disingenuous.
not make it clear to them that that was important. There was no motion filed by the defense.
At what point in time?
This is leading up to trial.
Okay.
At that point, there had been no request by the defense for video of the Sallyport area. What I learned is that Trooper Proctor had requested Sallyport video from the Canton Police Department. And the person who was the custodian of Canton Police Video, who would download it from the DVR, was Sergeant D.G.M. Petro. He made a request shortly after this event on January 29, 2022. Sergeant D.G.M. Petro downloaded video from the front wall camera, which was later characterized as the blurry camera, and he left it at the front desk. Trooper Buchanan, at the direction of Trooper Proctor, picked up the video and he brought it to Trooper Proctor. Trooper Buchanan did not look at the video at that time. It was given to Trooper Proctor. Trooper Proctor did not provide it to the prosecutors. So Trooper Proctor was aware of the video. The prosecutors were not aware of the video. That video is the same video that Sergeant D.G.M. Petro says that he downloaded the video in 6-hour segments, and that contained the front wall blurry camera inside the Sallyport and camera in front of the police station. That remained with Trooper Proctor for some time. In June, around June of 2023, Trooper Proctor then made a second request from Sergeant D.G.M. Petro.
Even though we already had it?
For different cameras. He wanted cameras, a camera angle of outside the Sallyport area, so when the tow truck dropped the car off, leading into the Sallyport, which is now characterized as the exterior Sallyport video. Again, Trooper Proctor asked Trooper Buchanan to go to the Canton Police Department and pick up a copy of the downloaded video. Trooper Buchanan went to the police department, picked up the CD at the front desk. That CD had a yellow sticky tab on it with Trooper Buchanan's name, and Trooper Buchanan wrote in the case file on that yellow sticky. He brought the CD to Trooper Proctor. Again, Trooper Proctor in June 2023 had a copy of the exterior Sallyport video, but did not provide it to the prosecutors. Both of those videos remained dormant. When Trooper Proctor was called to the federal grand jury, essentially he testified or was asked about video and said that he reviewed video. Now, this was not evidence that the Commonwealth intended on introducing or had any specific interest in. There was no particular discovery request by the defense, and there was no order. But upon reading that grand jury testimony, ADA Lally reports that he then inquired about the video. This is
Inquired of whom?
Trooper Proctor.
Okay.
This is shortly before trial. ADA Lally was given a copy of one of two of those productions. He was given the copy of the front wall video, which also contained video of outside the front of the police station. That was quickly turned over after Attorney Lally received it on April 4th, 2022. So what we know at this point is Trooper Proctor has this original production on April 4th, 2022, shortly after January 29th, 2022. I'm sorry, it was provided April 4th, 2022.
2022 or later?
No.
It was later, right?
It was
Because
later.
the federal grand jury was later.
He provided it on the eve of trial. So it was April 4th, 2024. So we know this production on April 4th, 2024 was in the hands of Trooper Proctor shortly after January 29th, 2022. At this point, the prosecution team is still unaware of the June 23 production, which has Trooper Buchanan's name on it, which shows the exterior Sallyport. As trial began, there still was no specific order or request. The chief of police saw something about the trial, and let me rephrase. Prior to the trial, it's reported that Attorney Yannetti was discontent because the video of the front camera Sallyport was so grainy, intermittent, and not continuous. And that's an accurate description of that video. Chief Rafferty, in response to seeing Attorney Yannetti's concerns, then asked Sergeant D. Giampetro to see if there was another camera or to produce any other video from the Sallyport. Sergeant D. Giampetro then downloaded video from the DVR, which is the second camera that is inside the Sallyport, known as the inverted camera, or now characterized as the inverted camera. That was produced April 23rd, 2024, given to ADA Lally, then given to the defense. And so at that point, there are 3 video productions that exist. The first turned over to the defense April 4th, 2024, the second April 23rd, 2024, and the June 23 production of the exterior Sallyport has still not been turned over. It's in the possession of Trooper Proctor, and the prosecutors do not know about it. After the trial, one of the employees from Norfolk County, Colleen Crawford, went to the Sallyport and looked at the DVR system. And when she looked at it, she saw that video still existed on that system. Although there was a 30-day overwrite on that system, the system had a number of backup hard drives, and because of the backup hard drives, the video existed longer than 30 days. She wrote an extensive report that was turned over to the defense, and this is after trial. The report notes her investigation about all the different videos, and it summarizes everything that she saw in that July 2024 visit. As I mentioned earlier, in August, Chief Rafferty provided video of the hallways that included some video of Brian Higgins, and she accompanied a letter or a note.
LOL.
I learned that that video
JK.
was copied during the trial. And it is noted in the sergeant's letter, the chief of police and the sergeant were downloading video, not in response to a motion to compel or produce, but rather because they had concerns about accusations that were being made about the department, and they were saving video, in their opinion, or from their perspective, to help defend against future false claims against them. They downloaded.
Let that part sink in. Let that part sink in. They have access to all of this video, and they are not turning it over because, even though that is their responsibility, that is their duty, they are not turning over this video that they are required to turn over, but they're holding on to it in case they're accused of anything else. Let that sink in.
A number of videos that were then turned over in that August 2024 production. When I first learned of that August letter and note, I turned it over to the defense immediately. The issue came up regarding the DVR in November, and as we've litigated extensively, so I'll simply summarize it, I invited the defense to come to the Canton Police Department. Given the intermittent or spotty production of video, I thought it best they have an opportunity to look firsthand, although I didn't know if the video would exist, as I've said. And then when they came in December, I think it was December 12th, if my memory serves, and learned that there was no longer video stored because it had been overwritten, I then went to the Canton Police Department so that I could have a closer look at the video cameras to see if there was something missing. I toured the entire station, I learned about the videos, and then as a consequence, I spoke to the chief, other officers, and the sergeant. Unexpectedly, the sergeant told me that he would click and drag copies of video when he would download them from the DVR. Inevitably, we had the litigation about whether the defense was going to download in person or not. And then, as I tried to finalize my investigation into the tapes and realizing there was no actual written chain of custody, I wanted best to memorialize it. I had been reviewing all files, data, hard files, but I had not been on the case long enough to review everything, so I asked that the parties of the Commonwealth look through all files, all databases, so that I could help facilitate my review. At that point, I was provided by Trooper Tully the June 2023 CD with Trooper Buchanan's name on it. That is the exterior Sallyport video. And within 24 hours, I provided that to the defense. I then asked both the sergeant and Trooper Tully and Trooper Buchanan to write reports. Since there was no chain of custody, I wanted best to give as much information as I could and document the history of the video. That, Your Honor, is a summary of everything that I had learned, the investigation, and the production of the videos.
Do you know which investigator's file it was found in?
Trooper Proctor's.
Nothing to see here.
Okay.
Your Honor, I have 3 separate arguments. I will proceed with the videotape argument since we've lodged into it.
Sure.
Okay. Now, the defense has made a number of conclusions that there was somehow videotape that was tampered with. There is absolutely no evidence whatsoever, none. It's not even speculation. There's no evidence that any videotape was ever tampered with. They say it, but there's none. I have seen none. They have produced absolutely no evidence that any video was altered or tampered. The defense lodges the idea of bad faith, that there was some type of advantage and that this video was withheld from them on purpose. And again, that is a baseless claim. If the government was going to hide video from the defense, they never would have got it. Maybe they would have got something after I came in and looked. They would have not got this production in April 2024. They would not have gotten the production if the government was looking to hide anything. And so the idea of intentionally withholding or bad faith is just characterization by the defense. The words Brady have meaning. Now, first, Brady needs to be exculpatory, and that's going to be something I think I can demonstrate does not fit this case. And secondly, in order to compel the court to conclude there was some type of remedy that should be issued, they want the court to conclude, like they do, that there was some type of tampering or some type of destruction of evidence. There was none. There was none. Now, Trooper Proctor had this video from June 2023 in his file. And I think the best evidence that this was not intentional is if you review Trooper Proctor's trial testimony.
So do you have a volume? Is it at the same place that Ms. Little gave me?
Well, I have the same volume. They gave you a fragment of his testimony, which was about 3 sentences. But if you actually read
you're one we talking about context
of his testimony that deals with this video, and it begins on page 133. What you will see, and I won't spend a half hour reading it, but what you will see is that Trooper Proctor was aware of the grainy video, which was the video that was provided right after January 29, 2022. He was unaware of the inverted video until it was produced right before trial or right during trial by the Canton police. And you can also see that he in no way was hiding the June 2023 video, because you can see the confusion between all the parties at trial. Attorney Jackson is asking Trooper Proctor about video, and Trooper Proctor is explaining there is a Sallyport video, and also there's an exterior video outside the Sallyport. And it is clear that Attorney Jackson does not have that June 23 exterior Sallyport video because he's very confused in the questioning of Trooper Proctor. And Trooper Proctor continually tries to explain that there is both the Sallyport and there's the exterior video. So clearly Trooper Proctor was aware of the exterior Sallyport video, but it will be clear from the reading of his cross-examination that there was no intentional withholding.
Is that clear?
He should have, since it was in his possession, whether it was relevant to the government's case or not, he should have provided it to the prosecutor, and then it would have been properly provided. But it was his oversight. There was nothing intentional or advantageous about it because he struggled to try to explain to Attorney Jackson. And so it's also notable that Attorney Lally never has an opportunity to ask more details about those. Well, he has the opportunity, but he doesn't ask more details about that misunderstanding because he's wholly unaware that it even exists. It's a confusing moment, but it clarifies that there's nothing intentional whatsoever about this course. And so it's important that although the defense now suggests there's something exculpatory about it or something about it that's important, it is important to note that the defense never filed a motion for the production of the Canton Police Department video. It is not incumbent or assumed that the Commonwealth is going to obtain every video from every part of a town during an incident. It's not assumed that they will do that. The Commonwealth seeks evidence that they think is exculpatory. They seek evidence that they think is relevant and material, and when they receive it, they are supposed to provide it. There are many cases where video from a police department is never provided to the defendant unless they ask. Or many cases where it may be a video of the booking, but not the hallways, not the bathrooms, not the back parking lot. Put in context that the defense theory was an evolving theory throughout this case to this day. The defense theory was that it was some third-party culprit, unidentified, who committed this act that led to the death of John O'Keefe. In fact, if you see earlier interviews, the defense position publicly was, you know exactly who did it, intimating that there was a specific person. Now that recently has changed. If we see the recent interview 2 weeks ago on Fox 25, the quick answer was, we have no idea who did it. We don't have to know. And so this fluid position is not noticed to put the Commonwealth on notice. They're supposed to chase down every potential idea or creation that the defense has. It's important to look at the motion that has been presented to your honor on behalf of the defense where they claim that they moved to preserve video evidence. And when you look at that motion, the best it says is that they moved to compel physical evidence. That does not put the Commonwealth on notice of video evidence at the Canton Police Department.
Was this the Stoughton District Court motion?
It is.
Okay.
And I know the Superior Court did not adopt it. However, I think the Commonwealth being on notice is the point. Even if it's in district court, I think it's the Commonwealth's responsibility.
I agree with that.
Okay. And so, Attorney Yannetti, and I've mentioned this before, was very prolific in his pretrial discovery motions. Very meticulous. And when you look at his meticulousness, if there was a need or a desire for video, he certainly would have asked for it. He didn't. In fact, when you look at the perspective of Attorney Yannetti, you don't have to look much further than his characterizations of how he sees the difference between the crime scene and the Canton Police Department. I've attached, for your honor and for the defense, exhibit number 4, trial testimony of Trooper Nicholas Garino. And when he cross-examines Nicholas Garino, he is pretty clear that there is a difference between the Canton Police Department and the crime scene. He cites on page 75, but you'd agree with me, the Canton Police Department wasn't the crime scene, correct? And Trooper Garino says, I never said crime scene in my report, I wrote scene. And Mr. Attorney Yannetti iterates, okay, well, Canton Police Department was not the scene of any crime, was it? So the defense is hard-pressed now at this moment where they are trying to create prejudice that doesn't exist.
Oh, shut up! Look, that was specifically because we were told by Morrissey in his office and former FBI agents who use their evil on Twitter now, we were told by all these people that we were all crazy for saying that, you know, that Proctor, or that report said that, Proctor went to the crime scene, and they're saying, well, crime scene is Canton PD. We were gaslit and told that we're all crazy for saying it's not. And then they're in trial and they're like, oh, it's not. And we're like, okay, well, that's what we were saying. And you've been telling us all along. And now they're flip-flopping back. And now all of a sudden it's...
To convert a motion that they filed with very specific intentions for physical evidence to now suggest that includes Canton Police Department because the Canton Police Department is somehow the crime scene. It doesn't convert. In argument, Attorney Jackson characterizes not only Trooper Proctor's testimony, and I encourage the court to look at that because when you read it in context, I think it clearly screams that Trooper Proctor is hiding nothing whatsoever.
Yeah, right.
But if you look at Trooper Buchanan's testimony, On June 6, 2024, if you start at page 103, Attorney Jackson, and to paraphrase, I'm not quoting him verbatim, suggests that there's something about Trooper Buchanan that is lying about his position or about what he saw, or that Trooper Buchanan admittedly saw the inverted video. Not the case. Trooper Buchanan reported that he did not see the inverted video until after Canton produced it, because how would he see it before Canton produced it? And that was in his preparation in May. And he did not say that he sat down with ADA Lally and watched the inverted video. He was asked, were you shown any of the videos that you've seen in anticipation of your testimony? Now remember, there's not just Canton Police Department video at that point. There is video from Ring, Town Hall, a number of different places. And he said, not during the first meeting, I did review video during the second time. Question, okay. And that video that you did see the second time, was that the interior video of the Sallyport that we saw yesterday, correct? He says, Trooper Buchanan, I'm just trying to remember exactly what video I saw. I had reviewed videos outside of our meetings. That is what he put in his report about reviewing in May, not with ADA Lally. So I don't remember exactly what video Mr. Lally showed me. That wasn't the characterization that was provided in argument. This is very different. Question, but you do recall seeing the video that you saw yesterday, the sort of clear one that has the crime scene tape being put up and all that. You've seen that one before. That's the inverted video. Answer, yes. I'm on page 104. And that was with Mr. Lally, correct? Trooper Buchanan, clearly. That is not correct, because I do not recall when I saw that video or what video I saw with Mr. Lally. That sworn testimony is not only in stark contrast with the characterization that was offered by the defense, but it directly contradicts the conclusion they asked you to reach, that Trooper Buchanan watched this video with ADA Lally in preparation for trial. Therefore, it is a lie that the Canton Police Department provided the inverted video sometime earlier. That's sworn testimony. Now, again, trying to assert some type of relevance, the defense suggests there is something in the federal materials that would show relevance, because Mr. Higgins said in the federal materials that he does not believe he made any phone calls. If you were to look at that testimony in the federal materials, you would see there was an enormous amount of conversation about the period in which he was sleeping. And there were dialed calls between him and Mr. Albert. And so you have to look at it in context rather than say it's an unequivocal denial and there's an aha moment. There is no aha moment. So,
do you have the grand jury cite? I think I might have got it from Ms. Little earlier, but the grand jury testimony of Brian Higgins, I have it. It's just easier if you have a cite to that.
I have a tab, but I don't. Perhaps Attorney
I'm sure
McLaughlin
Ms.
does.
McLaughlin can get it
I'll
from.
provide it momentarily.
All right, thank you.
So what really arises from the subterfuge is that the defense did not ask for video. There was video provided when the prosecutors learned about it. There was video that was in the hands of Trooper Proctor that should have been provided to the prosecutor that wasn't. There was nothing done to alter or taint the video. There was nothing destructive about it. There was no tactical advantage. There was no benefit to the government. And clearly from Trooper Proctor's testimony, there was no effort whatsoever to hide it. It should have been managed better, no doubt. But there was nothing about it that was prejudicial. There was nothing about it that showed tampering or altering. And so ultimately, the import of the defense's argument is that this evidence, this information, is exculpatory. It's exculpatory because what they claim is that it would show that Miss Reed's taillight was cracked, not missing a piece. Now, first thing we look at is Nick Barrows' testimony. And if you have an opportunity to look at his testimony, on page 12, line 1, the defendant told you part of the story. I saw there was some damage to the rear taillight. To my best ability and recollection, that taillight was not completely damaged, it was cracked. But they forgot the next part. and there, pause, a piece missing, but not completely damaged. That's exactly how we see Miss Reed's car later on after it is at Canton. The entire taillight is not missing. There is a piece missing.
Not a piece, it's the
That
majority
piece,
of it. That's the problem.
where the fractures of it are found at 34 Fairview, right near Mr. O'Keefe's body. The same parts of the taillight fragments that are found in the sleeve of his shirt. And so it's not simply cracked. Even the witness they tried to lean on, Mr. Barrows, says more. And so if that taillight is not just cracked, if that taillight is missing, then there is nothing exculpatory whatsoever about the Canton video. It's a red herring. Because there can be no plant of fractured taillight if it's already gone before it gets to Canton. There can't be. And so when looking at the evidence, it is unequivocally clear that piece of the taillight is missing well before that car ever gets to Canton. And so we can quibble and we can dispute and we can go back and forth all day, but the best way is to just show you the evidence. And so when we look at the evidence, let's start first with the fact, the claim that the Sallyport videos were tampered with. Canton went back before January 29, 2022, and they took samples of the video to see if it was in the same condition, inverted for the back wall and fuzzy for the front wall. And we have those, and we've turned those over to the defense, and I just want Your Honor to see a small clip of that to show this condition, these conditions existed before this case was even a moment. So with the court's permission, I'm going to ask to put up exhibit number 2. Exhibit number 2 shows the inverted camera from January 1st, 2022. Now this is 28 days before Ms. Reed's Lexus hits the Sallyport area. Now you can see, if you stop that please, thank you very much, on that wall, on that garage wall, there's a 4, it is backwards. This Sallyport video was not doctored by Trooper Proctor. It wasn't altered by Trooper Buchanan.
Okay, the real question is, how did you get this?
It was
if it
in
overwrites.
existence well before Miss Reed's car showed up to that Sallyport. Similarly, front wall camera, could you please put on exhibit 3?
And didn't turn it over. And they misrepresented it to the jury. That's the even bigger part, but...
Exhibit 3 is from January 28, 2022, a day before Miss Reed's vehicle makes it to the Sallyport. And you can see the quality. It wasn't distorted on purpose. It wasn't manipulation by the state police. This is the way the camera worked in Canton. Thank you very much. And so the idea of tampering, we can claim it, we can assert it without fact, but we can prove it did not happen. Now, what we know is that missing taillight was not tampered with because it was gone hours before police even touched Miss Reed's vehicle. At 5:08 a.m., she left Meadows Road. That's John O'Keefe's home. And when she left at 5:08 a.m., that taillight part was already missing. If we look at exhibit 6, please. This is from the ring video of John O'Keefe's home. This evidence directly contradicts the idea that the Sallyport video is relevant to show any break or planting of evidence. As Miss Reed nudges into Mr. O'Keefe's car, she will pull forward and we'll stop the video in 2 spots so you can get a clear look of that rear taillight missing. Forward, please. Thank you. And then ahead one more. You can see the white light shine. Stop. you can see it clearly missing. You can't plant something that's already gone. And the reason why you see white, it is a red taillight cover, and when the red is missing or gone, as it is in this case, the white bulb still shines, and that's why it shines white. The defense position is also contradicted by the ARCA witnesses. If we look at Dr. Wolf's testimony, day 31 of trial, it's noted as Exhibit 10 in our package, page 36. ADA Lally asks the good doctor, now doctor, in the course of your analysis or review of materials here, were you ever provided with a video of the defendant backing out a garage and making contact with Mr. O'Keefe's vehicle in his driveway at about 5:07 in the morning on January 29th? He says, I'm not aware of that. And then if we move to page 124, line 1. Now, line 2. Now, as far as you're aware from your review and your testing and everything that you did in this case, if a collision occurred at a lower speed, say 1, 2, anywhere from 0 to 5 miles an hour, would that create the damage to the taillight that you observed in this particular case? And Dr. Wolf says, at that speed, no. We provided notice of our own expert. And there's one thing, many things, but one critical thing the experts will all agree on. That nudging did not cause the damage to that taillight. The defense position is also contradicted by dash cam footage. Sadly, an officer went to the O'Keefe home to check on his niece and nephew on that tragic day. And when he did, he had a dash cam video further reinforcing that that taillight is missing well before that vehicle makes it to the Sallyport area. If we could play Exhibit 7, which is the dash cam footage showing Mr. O'Keefe's car in his driveway at 8:22 a.m. If you could close up to the court, please. If you compare the right side to the left side, although covered and impacted by snow, if you could more close up, please, you can see that taillight, just like the detective from Dighton said, just like the 508 ring video shows, is missing. Is missing. There's no plant. The defense's position is also contradicted by the alarm.com video that we received pursuant to Rule 17. There are two videos, 8 and 9. If we could play Exhibit 8, please. This is the defendant's car arriving in Dighton in the driveway. The defendant on the passenger side, and you can see them walk to the back of the car near the right taillight and stop. And if the question is what are they stopping for, we can play video 9. And this is when the car is being put on the tow truck before it makes its canting. And just like 508 in the driveway of Meadows, John O'Keefe's home, you will see that right taillight shine white, showing the missing taillight cover on 2 occasions. If you have an opportunity to stop the video at the important points, please do so.
Can you lower it?
We cannot.
Can you zoom in on it?
Your Honor, I would encourage the parties to look at it on the computer. The clarity is much better, and it's very clear, the white light missing video. I cannot see it clearly on the screen.
So will you give me a flash drive of all of these exhibits?
Oh, there we go.
Okay.
That's the thing.
If you look at it on a small screen, see right there?
I do see it.
This is
and then
all.
you'll see it again.
This is all.
So the
cross-examination
alarm.com
stuff.
video contradicts the defendant's position that there is anything exculpatory about these Sallyport videos. In fact, this whole idea of third party or plant doesn't come to town until 9 months after Ms. Reed is indicted. Perhaps the best evidence that contradicts the defense position that there's any relevance to the Sallyport video, that there's any type of plant by anybody, is from the defendant herself. Ms. Reed spoke to Gretchen Voss on June 20th, 2023. And in that testimony, or in that interview, she said, when my car was seized, there was a few small pieces of taillight missing that I had picked out at John's at 5:45 before we drove over to Fairview. I'm showing Jen and Kerry, look what I just did to my light. And I'm worried that there's gonna be some kind of electric short circuit. There's like the bulb is showing and some of the red plastic is missing. So I picked pieces out of the light housing that kind of collapsed within the light and dropped them in John's driveway. And so I say to the court, the production should have been sooner. It should have been cleaner. This should have been a log or an entry. The failure to provide was inadvertent. It was unfortunate.
Hold on, we're going to go back in here again.
But it's not Brady. It's not exculpatory. It's not intentional. It's not tampered with. It was inadvertent and inconsequential because the evidence is overwhelming that that light is missing before the car makes it to the foot of the Sallyport, so there can be no plan. That is my argument regarding the Rule 14 issue. I would like to have time to speak about the claim of jury tampering. I understand the temperament of the court. I'm not tone deaf, but it is a claim that was lodged that has collateral consequence. And I think it's important for me to be able to address it. May I?
Yes.
No. Ugh.
The claim of jury tampering is probably one of the most serious claims that one can make because it's not simply an attack on a case. It questions the fabric of our entire judicial system. If a good juror comes to court and believes there is no integrity in the court or in the judicial system, it is impossible for a fair-minded juror to even consider evidence because they do not trust the system to begin with. And if a government actor or a trooper or a police officer tampered with a jury, that would be one of the biggest, most abhorrent transgressions that could happen because of the collateral consequence of tampering with the jury. It would take away the community's belief in our system. On the other hand, if there is a claim of jury tampering and it's baseless and there is no evidence, it is not only a direct attack on the judicial system, it would seem to be an effort to try to undermine the authority of the system in court before a trial to impede the ability to have a fair trial. It is an extraordinary claim. And it's notable, the defense motion to dismiss, it's not just a motion to dismiss, it's a motion to dismiss for extraordinary government misconduct. So when you make an extraordinary claim about jury tampering, there should be extraordinary evidence. There isn't even ordinary evidence. There is no evidence of jury tampering in this case. Now, I don't want to belabor this, but it's important because of the consequence of what happens when a claim like this is lodged. There is damage. And while I'd rather sit down, as I said before, a lie unchecked becomes the truth. And so, how does
you don't get
one
to use that after
propagate
you lied to the court.
claim of jury tampering when there's no evidence? Well, first you need to plant the seed of corruption. And all you have to do is whisper it and hope the poison goes out there and is resonating in the potential community. And so what happens is
He can't possibly even believe what he's saying right now because it's like planting the seed of corruption. Sir, we have seen it. Like, there's a reason that, like, Proctor is, like, going through all the stuff he's going through right now. There's, like, all of the stuff that's come out through all of the stuff that was done wrong, all of the you know, like this person got rehomed and this person's demoted. It's no longer just like you can't just say anymore that, oh, the defense is just trying to do this. There's corruption. There is like stuff that y'all have screwed up on. There is stuff that you continue to do, that you continue to hide. You don't get up there and just pretend like this is all some fairy tale that's being spun as they go in order to try to dismiss this, because as much as you want that to be true, it's not true. This is all based on stuff. If it wasn't, then none of that stuff would have come out during trial. Like, you don't get to just get up there and pretend like this is baseless when there's a whole bunch of base for this. There's a reason that everybody is watching what's happening right now. There's a reason that so many people are pissed off. There's a reason that there's a police audit happening in Canton right now. There's a reason that all of this is going on. It's not because they're planting the seed of, like, shove the seed up your stupid nostril and listen. This is no longer something that can be denied.
This, the defense finds a willing partner who covets an opportunity to meet with the defendant. They find a time, like after the Super Bowl, so there's this national exposure, and they just seep the information. They just seep it into the public and let it resonate. There can be no retort. The government can't respond. No facts, no evidence. Just saturate the public. Now, it's important to see or hear or read what is said, because this really is the acorn that is being planted that cannot be rebutted. And it's not insignificant that this same information before this interview is being disseminated by Mr. Kearney. This idea that there was tampering by Lieutenant Fannin. Not a coincidence. And so during this interview that the defendant and the attorney have, the question's asked, I don't know why it's asked, but it's asked, there have been sort of these unsubstantiated claims in the atmosphere that there might have been some funny business with the jurors who were dismissed. Really? And Mr. Jackson says, right. The question, is this a real concern that you have? Is this something that you were looking at, or have you just dismissed it as a rumor? Answer, I never just dismissed that as rumor. Something like that, it's too convenient for the prosecution for us to just dismiss out of hand. Do I have any evidence, specific evidence that there was jury tampering? I don't have any specific evidence of it. And yet we have a motion filed 2 weeks later. Do I think there are questions that should be asked? Do I think that there are questions that have been raised about the way the jurors were dismissed and who was dismissed very specifically? And then it continues on page 13 of the transcript. Question. One of the state troopers who was involved with the Norfolk DA's office and on the periphery of the investigation was also responsible for the jury? Not sure where these questions come from. Answer, right. He wasn't that far on the periphery of the investigation. He was involved in the investigation. He was direct supervisor over the individuals that were testifying and over and about whom we had leveled some very, very serious claims and ended up proving those claims during the course of direct and cross-examination in the presentation of our case. That person, that supervisor, we found out well into trial. As a matter of fact, at the end of the trial, we found out is the very person who was governing the jurors. That's a question that should be raised. That is an issue that should be teased out. Should never, ever happen. That is the very definition of a conflict of interest. Question, is that standard in Massachusetts for just the DA's office to assign whoever they want to be sort of, supervisor of the jury? Yeah. Is it standard in Massachusetts? I hope not. Never seen that in my life. But if I had a nickel for every time I said I've never seen this type in my life as it pertains to the Massachusetts justice system, the criminal justice system, I'd have a lot of nickels.
So I didn't see that interview. I don't have the transcript. I'd like a copy of that transcript.
Your Honor, I understand, and I may be mistaken, we produced all of the exhibits to the court, and you should have a transcript. If not, I will get it to you immediately.
Okay.
Okay. So after step one, finding a vehicle to plant the seed, and they did that very effectively, the next step is they have to identify a target. Who are they going to blame? Who's going to be the villain? In this case, a villain goes from anybody that gets in the way. It could be a soccer mom, it could be a police officer, it could be a good Samaritan. Anybody that crosses the path is a target. And now they decided they were going to identify Lieutenant Fanning. Lieutenant Fanning is one of the most conscientious, dedicated, admired state police officers in Massachusetts.
You see that little stare down between him and Karen Reed?
After having his
First
name...
of all, I just gave him the same look, and Karen did too. I'm going to rewind so y'all can see that again. That little, woo! Go on and talk about how great Detective Fanning is, that lead prosecutor in Santa Barbara. Go ahead, hold up. Look at
the most
this is all bullshit.
Dedicated, admired state police officers in Massachusetts. After having his name attempted to be sullied all over social media, attacking his integrity and his name, I can dare say that Lieutenant Fanning is in a different position than many. His integrity is so reputable.
Oh my God.
None of that will break him or his reputation.
Oh my God.
But it happened.
Are you kidding me?
When you look at the motion filed by the defense in this case, and they found their target in Lieutenant Fanning, you look at this motion, page 15. It's important when they made this public pleading, getting back to my request for your honor the other day. You look at the bottom of page 15. It talks about Lieutenant Fanning and tries to align him or associate him with Trooper Proctor because Trooper Proctor's text message was on a chain that included Lieutenant Fanning. Lieutenant Fanning did not reprimand or otherwise correct his subordinate's disgusting and inappropriate behavior. As a result, he was investigated by the Office of Professional Integrity and Accountability for allegations of inappropriate correspondence between department members. True. But then they leave off the punchline. They put this in a public document. They try to smear him, degrade, demean, dehumanize.
Oh my God.
But what they leave out is that after this thorough investigation by the Office of Professional Accountability, where they took strong measures, very strong measures when they found something that they were not in agreement with, they concluded that these complaints were not sustained.
So we were all aware of that. I received verification of that through the Pleadings Council, was all aware of that. I just need the date. When was he cleared? When was that made public?
We'll have to provide that to you.
Was it prior to this? Was it prior to the motion being filed?
Yes, it was last year, last fall. I can provide the date right now.
Okay.
Trooper Lieutenant Fanning is not in a unique position.
I don't even know what to say.
Your Honor? Sorry. It was July 17th, 2024.
He is similarly situated to the many first responders and witnesses in this case. And then, without any basis, the defense then distorts that Lieutenant Fanning was in charge of juror security. He had control of the jury, and he had access to the jury. Think about what those statements say to our community, who are going to pile in here in less than a month to try to give a fair trial to both sides. Think about what those words mean. After selecting their target and trying to dehumanize him and degrade him, they then try to create an illusion of this grandiose havoc that is running amok.
Wow.
Trying to get the community to think Trooper Fanning controlled, had access, and tampered with the jury. Think about that concept. Not only is it an attack on Lieutenant Fanning, it is an attack on the integrity of the trial court. I've walked a lot of hallways in the trial courts over the past 30 years. And the heartbeat of trial courts is the court officers who take their duty so seriously. They help, they assist, they guide, and they have solemn pledges. They are charged with the responsibility of the jury. To suggest this is to suggest that the hardworking men and women in our trial court system who come here every day for everybody else's benefit, it is to suggest that they would cede their authority to the state police and abscond from their duty and responsibility to protect that jury with no basis whatsoever. That is the concept that they are promoting in this motion. The trial court personnel throughout the state are steadfast and dedicated. I've tried a lot of cases, and I think most of the lawyers in here have. It is without a doubt in Massachusetts that these dutiful men and women of the trial court protect and are sworn at the end of every case in jury instructions to protect the jury. And these trial court employees, especially here in Dedham, some of the finest, would never abscond that duty. And yet it is now in the public domain, this suggestion. The only way that you dispel innuendo, suggestiveness, unsupported claims, and the poison that can seep into the community, the only way you can stop that is with fact. So I'm going to list a few facts for the record. Fact: Lieutenant Fanning was not in charge of juror security. Fact: Lieutenant Fanning did not have control of the jury. Fact: Lieutenant Fanning did not access the jury. Fact: Lieutenant Fanning was part of a multi-agency cooperative effort to ensure the safety of the public and court participants, which required numerous local police officers and state police because of the bedlam that was created outside. Fact: Lieutenant Fanning never, ever, ever met with or interacted with any juror. Fact: at all times, Lieutenant Fanning worked from a remote location, jointly managing operations for the safety of the public. Never setting foot on this property when the jury was here. Never meeting a juror, never looking at a juror, never being seen by a juror.
Fact.
Fact: no evidence any trial court personnel ever ceded their obligations and duty and handed them off to Lieutenant Fanning. Fact: Lieutenant Fanning heard numerous rumors from various sources about a juror who expressed potential bias. Fact: Trooper Fanning never investigated, approached, or inquired. He heard the information and provided it to the trial court as is responsible, dutiful, and proper. And I'll repeat one more time, Lieutenant Fanning never, ever, ever interacted, controlled.
No, she doesn't like it when you repeat.
Juror.
She doesn't like it
Your
when you
Honor,
repeat.
These claims in the motion to dismiss have a theme. Different issues, same theme, same pattern, same effort. Your Honor should dismiss it outright, and we should move to trial. Thank you.
Fact.
If I may, Your Honor?
Yes.
Thank you.
I'm like, my blood is boiling. My face is red.
I'm going to address in reverse order some of the statements made by Mr. Brennan. And I want to talk first about this issue of juror interference, which is what we called it. These words matter. We've claimed that there's interference. He indicates that that would be an abhorrent transgression if there were interference with a juror or a jury. We agree. it would be an abhorrent transgression. The information that we have in front of us is not the information that Mr. Brennan just recited, which is interesting. I'll get to the facts that he very dramatically stated in just a second. Because this is a fact-based inquiry, one that we asked for standing right over there at sidebar and didn't get. But Mr. Brennan, with no support to back it up, and I'm going to ask a couple of pointed questions about that, recites these facts after facts after facts that he claimed absolved the Commonwealth of any transgression as it pertains to the jurors. And when I say Commonwealth, I'm talking about the Massachusetts State Police. Very clearly, in a clever, almost too cute by half argument, Mr. Brennan talks about the good court officers that are populating this courtroom and this courthouse, about whom we have made no allegation, no claim, nothing. We have nothing but the highest respect and regard for the men and women who wear that uniform and perform these duties. None, zero. And he knows that. But in an effort to create an enemy where there isn't one, he acts like we've insulted the court officers, which we haven't.
Oh, I'm mad.
He also said that Lieutenant Fanning stood up here and gave basically a CD, a resume for him, and said, "He's the greatest guy on the face of the earth." I don't know Lieutenant Fanning. I don't know if he knows Lieutenant Fanning.
Probably not.
Not really the point. It's in the personality contest. He said that we identified somebody with an unassailable reputation. We identified him? We didn't identify anybody. We were standing up at sidebar, fat, dumb, and happy, not knowing what was going to happen when somebody else identified him. It wasn't us. And by the way, everything that we filed concerning this was under seal. We didn't disclose anything in any court document. It wasn't a public document, it was under seal. Mr. Brennan then states that he was also a subject, this person with this unassailed career, was the subject of an IA investigation for his conduct on this case. It's not even about something tangential. It's about his conduct on this case, his supervisory role as it pertains to Michael Proctor and his, and I'll repeat it, disgusting conduct as it relates to my client and his text messages, etc. When he was asked about those text messages, his claim was, I was on vacation and I didn't read them. And ultimately, the Massachusetts State Police investigation cleared the Massachusetts State Police officer. We've seen that happen before.
You can hear
the
her
question, or questions, if I could, that surround this inquiry, and the reason that we included it in our motion to dismiss is because it appears that Ms. Reed did not get a fair trial because of this juror's dismissal. How would the person who's unidentified, to this day, unidentified, how would this person know who the juror sitting in one of these seats was if she was at a private location? I won't mention the location. How would they know? How would they know to identify her? How would they know what she said? How would they know to record her illegally, potentially, if that happened? How would they know these things? How would they know that if she was a juror, that she was a juror on the Commonwealth versus Reed matter specifically? And how would this unidentified person know of all of the authority figures to go to Lieutenant Fanning, of all people, who is then described to us after the fact as the, quote, commander of the extensive security operations that this case has required. And I went through that with the court this morning, but I just want to reiterate it one more time. Of course it makes perfect sense that we would presume that if he's the commander, I don't think it gets much bigger than commander. If he's the commander of all security operations, he's the commander over operations that are attendant to the courts, the actual court's security, the personnel's security, the party's security, to whatever degree that is necessitated, but maybe most importantly, the jurors' security. That is a reasonable next step to conclude, a reasonable inference from the facts that we were given. But we do know this. He was this same Fanning that was just randomly picked to go report this to, was also the person that was in Miss Reed's house seizing her phone just months before the trial. He's also the person that was interviewing witnesses or supervising the interviews of witnesses in this trial. He was also the person that was on the text messages between Proctor and his buddies at MSP talking about her and trying to find nudes. We know all of that existed. And yet, we were denied an opportunity, Your Honor, an important opportunity, to simply inquire before this juror was dismissed. That's all we asked.
That's part of
Let's
the
get
case
Lieutenant
law
Fanning
they
in
cited.
here. Let's find out what the source of this is, and let's figure out, is it even remotely true? Remember, the juror never said it was true. But lo and behold, minutes before I stood up to give my summation, that juror's removed. That's the problem. This isn't about court officers and besmirching court officers' reputations. That's not what this is about. This is about what happened at sidebar in the matter of minutes that denied Ms. Reed her constitutional right. There's a couple of other points that I just want to make. Mr. Brennan started his comments by talking about the Sallyport video and how unimportant it is. How unimportant that video is. I'm not going to go through all my points again. The court doesn't need to hear that. But I do want to make this point. He says it's not important. There was nothing to see here. We don't pull videos normally. Yeah, of course you don't pull Sallyport videos if you're investigating a bar fight. This was the purported murder weapon.
Exactly what I said.
This truck is the thing that the Commonwealth suggests was used to kill a cop. You think the video of it being pulled into the Sallyport might be of some evidentiary value? I don't know. Can't imagine why that would be important.
That's literally what I said.
Might have some evidentiary materiality. But I do know this. I do know this much. There's one guy who thought it was important. The lead investigator.
Bam.
He pulled it all. All of it. He was super convinced it was important. And he's the guy that once pulled it, hid it from us for nearly 3 years.
That's important. That's important. You can't ignore that.
Mr. Brennan spent some time talking about the difference between cracked and missing. Interesting point. Now, I'm not going to go through a bunch of videos and audios. The court has seen all the pictures and photographs that it needs to see, and the court has a very, very good memory.
She knew it was cracked.
We've never, ever disputed that the light was cracked at 5:07 or so a.m. That's how it got cracked, is the point. It got cracked on that traverse. And a piece was missing. A piece was missing. Not according to me, according to another agency's sergeant, Barros, who said a piece was missing, but it wasn't completely damaged. Recall that when that light was completely reconstructed with the 46 six
It was still
47
missing the
pieces
piece.
that were purportedly found, well, they were found at or near 34 Fairview. And then they were reconstructed. Does the court recall what that reconstruction looked like?
Missing
That taillight was put together almost in its entirety. Almost. Except a piece was still missing.
Yeah.
There was a piece unaccounted for. There's a big difference between a crack and the condition of that taillight, which we've now seen, where literally the entire lens material is basically gone. There's a few shards left on some edges, but the entire lens is basically gone. So yeah, it's relevant. And it's exculpatory. The condition of that light when it pulled into the Sallyport driveway. And with regard to the inverted video, again, Mr. Brennan says there's nothing to see here. We've got inverted videos dating back days earlier. Then why, if that's such common knowledge, then why did Mr. Lally and Sergeant Buchnick, in front of a jury, present that video as a true and correct presentation of what that car looked like and where that car was? Mr. Lally actually asked the question. I don't have a page in sight now, but I remember it because I was sitting here. He asked the question, did you see Mr. Proctor? It was something, I'm paraphrasing, something along the lines of, did either you or Trooper Proctor approach that right passenger taillight? And the answer was no. Because on the video that was being played, it looked like the right passenger taillight was the one closest to the jury. And of course, Trooper Proctor walked right around that and went over to the other taillight. Except when you reverse it, you realize that's the right taillight.
Is there a copy of the reverse, the one that you played? Is that in the exhibits for today's motion?
No. The one that's been corrected?
Yes. I'd like a copy of
I
that.
don't think I have. Sure. We can get that for the court immediately. Also, he played a video of the grainy video. Showing, hey, look, some of these cameras are just grainy in other particulars as well, at other times and places. Maybe, or maybe not. What's interesting is the grainy video that we saw, if my memory serves me, and it's my memory, and it's being taxed at this point, but my memory is the chyron on that video, in other words, the running numbers, was at the bottom. Yet the video he just played was at the top. That's the exact same video. If it's apples and apples, oranges and oranges. Why is that different? That's interesting. And with regard to Ms. Reed's actual statements in that interview that was played, or I'm sorry, it wasn't played, it was recited. She said, some of the red plastic is missing. Some of the red plastic is missing. In other words, a piece is missing. It's completely consistent with the condition of that taillight before it was at the Sallyport. With regard to the facts that were recited by Mr. Brennan at the very end, every one of those is unsubstantiated. How does he know all that information? Mm-hmm. Who has he been talking to? And why don't we know about it? If in furtherance of this motion, there was an interview done of Lieutenant Fanning that laid out all of this information about not having contact with jurors and not doing this and not doing that, but yes, doing this and that and the other thing, why is the first time I'm hearing about this when he stands up and tells us? That has been the pattern of this Commonwealth's presentation to this court and in front of the jury consistently. That is the punctuation mark at the end of the sentence. Why am I just now getting that? Why wasn't that appended to his motion? Was there a conversation Mr. Brennan had with Lieutenant Fanning that we need to know about? This is exactly why, Your Honor, exactly why. If this court is not inclined to dismiss this case, and it should, the maladies of the Brady concerning the Brady violations and the discovery violations are so manifold in this case. They cannot, it's irremediable harm. Irremediable harm. This case should be dismissed because of the conduct of the Commonwealth, including Michael Proctor holding on to those videos, hiding those videos, and then Others involved with strategizing how to use the videos against us, against the defense, in a murder trial without our knowledge and without giving us the videos. But if the court, in the face of all this, determines that it's either unconvinced at this juncture to dismiss this case, then we urge the court to have an evidentiary hearing. That's what this demands, at the very least. An evidentiary hearing so that the court can perfect the record. We shouldn't be guessing at things. And I'll submit.
Any follow-up, Mr. Brennan?
No, thank you.
Mr. Yannetti, do you want to say something?
I don't think I need to in light of that presentation, Your Honor.
All right. I know you want to do your motion, Mr. Alessi. I can
Did you hear that? Hold on. Did y'all hear that? Damn right. Hold on. Go back and listen.
not imagine.
In light of that presentation, Your Honor.
All right.
Damn right.
I know you want to do your motion, Mr. Alessi. I cannot imagine that you can summarize it all in 10 minutes, can you?
I cannot, Your Honor.
Okay. So I'm not going to have anybody back here this week or next week. We'll hear that on the 18th when we hear everything else. I urge you, Mr. Alessi, to condense it as much as possible, okay?
I will.
I mean, your pleadings are very thorough.
I will do so, Your Honor.
Okay. Not yet. So I gave the parties until, instead of Friday for all the motions in limine, next Monday is fine. But by the following Friday, I want any responses, oppositions, any responses to the other side's motions. And then we'll have a hearing on the 18th. Jim, did we put aside any other days as well?
We did, I thought. Just a sec.
Yeah, we did 18 and 19.
I don't know who it was that said it.
All right. I would expect that we would finish all the motions in limine in 2 days and wrap up whatever we have here. All right. All right. Yes.
Fox 25 produced the materials at the beginning of March 1st. I went down to see if I could get a copy. It's on a hard drive. I can't simply look at it in the clerk's office. I would like permission from the parties to be able to make a copy of the hard drive, or if I can get the hard drive and make a copy and return it.
Does the defense want a copy as well?
Yes, Your Honor.
All right. So you can make copies.
I'll make 2 copies and then I'll return the original to the court.
Okay. All right.
Just before you leave the bench, Judge, I do not want the court to decide that motion for sanctions until I just supplement the record. I could do it in 3 minutes, and if
Go
you
ahead.
don't, you can cut me off.
Go ahead.
Thank you.
Go ahead.
Just briefly, Judge. Yesterday, Mr. Brennan represented to this court that I had made an extrajudicial statement regarding Mr. Morrissey and the federal investigation. You'll recall that I stood up in rebuttal and said that it was in court advocating for my client. He then said court TV is not a courtroom.
So before you go further,
Yes.
I don't know if Mr. Brennan was going to give me a court TV site on that. Is
Right.
there one, Mr. Brennan?
I'll have to provide a video. I think that Mr. Yannetti is referring to that comment that was a court comment. And so I intend on remedying that record. There was also a conversation after with court TV.
All right, so provide it to Mr. Yannetti. Mr. Yannetti, I'll give you an opportunity to respond once you get.
So, okay, so let me get this straight. Time out. Hold on. Because y'all know I was on medicine yesterday and I was kind of in and out of it. So Brennan said that Yannetti had an out-of-court statement on court TV. He got his little snarky pants on and said that about Yannetti, and now Yannetti is having to clear the record again, saying, no, it was made on a Zoom. Is that what just happened? Did Brennan just get, did hashtag Brennan just get busted again?
But go ahead, you can tell me. What
Hold on, I just want to hear him say he's going to remedy.
I intend on remedying that record. there was also a conversation after.
Oh, he intends on remedying that record.
With court TV.
All right, so provide it to Ms. Giannetti. Ms. Giannetti, I'll give you an opportunity to respond once you get that. But go ahead, you can tell me what you want to tell me now.
Right now, it's out in the court of public opinion that I made this extrajudicial statement. I said specifically I did not. He contradicted me, and that's where we left it, and he said that he would produce the receipts. Now he's admitting he does not have the receipts. There was no court TV interview where I said anything of the sort. That was a Zoom hearing, excuse me, where I was arguing before Your Honor. I would just note, Your Honor, I don't think it makes sense that Mr. Brennan would have done this on purpose because it was so easily disprovable.
So are the other things.
It's troubling that he would make this damaging accusation without properly vetting it to see if it is true before he attacks opposing counsel. So that was disappointing to me. And I would just point out, and again, I only need 30 seconds. That,
you can take your time, Ms. Giannetti. You're not going to be 35 minutes.
Right. I certainly will not be. This new false allegation comes after my colleague, Mr. Alessi, co-counsel, Mr. Alessi, on February 25th, detailed 9 or 10 false statements that Mr. Brennan has made to this court. And I want to make it clear, I don't need an apology from Mr. Brennan. I don't expect one. But I think perhaps he should apologize to the court. He said today, a lie unchecked becomes the truth.
Yeah.
And I just would hope, Your Honor, that you hold Mr. Brennan to the same standard that you hold the defense team. And that's it.
Bam.
I certainly do. So, Mr. Brennan, if you do not have a site, then I need you to let us all know that as well.
I will. It's convenient to retort that there were 10 lies by the court that Mr. Alessi lined up. In fact, I looked at the transcripts. Some of his suggestions that I didn't read the paperwork properly, which is wrong. I didn't try to shame him today. It was part of advocacy, and I accept that. There was a conversation, and if you remember, when I related Ms. Giannetti's remarks, it wasn't in relation to 3.6. It was in relation to the fact that they were using the federal investigation to create innuendo that could not be responded to. But I will provide...
For your request for the gag order? In support of your argument for the gag order?
In response to how they had used federal materials that were under seal that couldn't be rebutted to make suggestions. It directly related to that point, not 3.6. But I will provide the videos. Mr. Giannetti is right, and the exact statement that I used was from a court hearing, but then there were subsequent statements made. And so my regrets to Attorney Giannetti, but it wasn't in the fashion of a 3.6 violation. That wasn't the intention. It was to show how they've used these federal materials before the case was closed to their advantage.
All right. So if you have the site, I'll give you until tomorrow afternoon to find the court TV site.
Very well.
If you have it, supply it to all, Ms. Giannetti. So I'm ordering the Commonwealth, if they have that court TV site, to provide it to all of us. And if you don't, provide that as well. Provide that information.
Thank you.
Thank you. All right, that's it for today.
All rise for the court, please.
You are muted.
I just don't understand how it can be so one-sided with this stuff, and that's not like that's just everybody's cool with that. That'll be in the podcast. Ooh, the stuff about fanning. Like, he's literally fangirling over fanning. I don't get it. I don't. At what point do you see how hypocritical you are? Like, there's got to be a point where that happens. At what point does it happen with him? Like, Saint Fanning is going to come down from you know, let me breathe. He keeps making these big statements, these big allegations, and he's doing this because he knows that that releases this whole like troll brigade to try to spread, you know, spread that misinformation. And then it's like in like little bitty side, you know, like footnotes from, it's like when a magazine has like a really explosive accusation against somebody and then they're like, oh, it wasn't true, but they don't like release a big thing saying that wasn't true. They put it like somewhere down in the footnotes of, you know, the magazine, like, you know, 2 months later. That's what he's doing. He's dirty. He's dirty. He is, I'm not a fan. And Laura McLaughlin is the one that said that he was in command, that Fanning was in command. Little B, thank you for the super sticker. Thank you, thank you. Ooh. Whew. Breezy, thank you so much. Fix Our Face Fund and for doggy treats from the vet. Oh, yes. Things hurt my ears after a while. I'll make sure she gets some more treats. I'm glad that Yannetti, you know, was able to stand up for his own self. It's just, it's crazy what they're doing. It's crazy. Taste the biscuit. Taste the goodness of the biscuit. I'm blown away. I'm blown away. I love that they keep using, Jackson and Yannetti both were using Brennan's theatrical arguments the same. Like kind of using them against him or whatever which is the same thing I did in my snarky little memes. But where he used, you know, a lie unchecked becomes the truth, and then, you know, he used that would have been nice to have. Like they're using his own theatrical arguments against him to kind of show how full of crap he is. It's crazy. It's crazy. Do I think that she will dismiss this? No. I mean, you can tell just by the way that she answers things, you know, you can tell what she's thinking. But do I think she'll do an evidentiary hearing? Probably not. Do I think there needs to be one? Yes. Yep. Crazy. Are mine? Oh yes, yes they are new. Well, they were from, I got them for my birthday. Birthday gift. Peter says he starts talking and then strings sentences together that don't make any sense. Yeah. I'm so... The audacity. The hypocrisy. It's crazy. Yeah, so I didn't watch the Baldwin case, but everybody keeps saying, you know, stuff like it was stuff like this that got that dismissed, and that it was way less than this. Ugh. Crazy. That says a lot coming from Peter because he tries to stay in the middle, but lately he can't help himself. Yeah, and I appreciate that because, you know, there are things where, obviously, like, you know, we'll talk about things on here kind of like live. And I am already annoyed. I'm already like y'all know how I am. Like when we first started this out, I was like, you know, I went into it thinking like, well, let me do my own little investigation, see what I can figure out, see what I think happened. And I went into this very open, thinking stuff just sounds weird. Let's go see, you know, let's dive into this and see what we can figure out. Which side is the conspiracy on? So I went into this very open, and the longer it's gone on, the more I'm like, are you freaking kidding me? Are you freaking, what are the odds? What are the odds? How many times did I say that in the last episode? What are the odds? I think after a while, you can only take so many things as, you know, coincidence. We're past that point. And I am annoyed. I am frustrated. And I don't have any faith whatsoever in this Commonwealth or prosecution or the law enforcement, which really sucks because it's not all of them. You know what I mean? Like it's not all of, I won't say it's not all the prosecution because I hadn't seen much good from any of them yet. But you know, I am a firm believer that even on some of the worst, you know, some of the worst law enforcement teams, there will still be good cops. They are not all bad. And it's the ones like this that give, you know, the appearance of impropriety, you know, like, and the like kind of above the law, you know, mentality. So that's frustrating because that's all we really get to see in this one. And then to have him up there like defending it is crazy. So when you see, I have my very firm views on this. So sometimes I'll go watch other attorneys who are not quite as snarky as me, who might have, you know, like I'll watch, there's one that I watch who's a prosecutor and was a prosecutor. And there's one that I watch, you know, defense attorney. And then like, I'll see for specific things, I'll be like, am I crazy? Like, let me hear both arguments. And Peter's one of those that he does give the good and the bad arguments on both sides. And seeing the things that he's saying about this, I'm like, it's very, you know, he's very balanced in his views. And like, even him, you know, that's why everybody's like, even he's, you know, like, what the heck is this? Yeah. It's hard not to. Don't see an update online. I saw that there was for Turtle Boy, it looks like there's a new witness intimidation charge that was filed that relates to that relates to Rafferty. So they talked about the fear must be defined. Calling in phony pizza orders. His attorney said he never did that. Judge wants to talk about the motorcade. So they asked about the rolling rally, stuff like that. The judge read everything. Cosgrove and Bradle had an opportunity to share additional information. Cosgrove is going first. This is all from Jessica Machado. If I was listening to a YouTube presentation and someone told people to send pizza to someone's house, that is evidence. So the judge said that there was arguments on both sides. This is all Jessica. Y'all can read through the whole thing. I'm not going to read everything, but you can follow her on Twitter. But she says, I will take it under advisement and get something back to you soon. The judge asked for a sidebar, and then they come back, and it says, this morning, I was informed of an incident last night. The defendant was at C.F. McCarthy's. That's Turtle Boy. Turtle Boy was at C.F. McCarthy's. It is next door and owned... It is next door and is owned by one of the witnesses in the case. At the end of the evening, the son closed the business next door. A camera from D&E Pizza that recorded Dr. Turtleboy walked up to the window, pressed his face against the window, then went into a 2-minute diatribe saying hello to the witness. What have you done? I wish he was alive today. All of this to Chris Albert. Cosgrove is saying that the intent was to harass and intimidate the witness. Bradel said he has nothing on this issue, not even a paper. And the judge said, do you want to continue? How about tomorrow? You have a right to see any reports and video. So the judge wants them back tomorrow at noon. So... So the judge told Turtle Boy, stay away from there, and we will be back tomorrow. So it's continued until tomorrow, and he's told to stay away from D&E Pizza. Yeah, so that'll be continued tomorrow. Yeah, I saw that I saw a picture on social media somewhere of them. What a day. The Karen looking back at him when he started kissing Fannon's butt, and then he looked at Karen, that was priceless. To be clear, if a jury was in there, it wouldn't have been a good thing for her to do. But there's no jury in there, and she can't fix her face either, so I really don't blame her, because that face that she just made at him when he said that was the same face I was making here in my kitchen. So... that was part of the best. Fanning involved in the Sandra Brushwork. Yeah, he's like lead investigator. Yeah, he has like in his, report, that it was suicide based on the evidence and the whatever. He is not as reputable as Brennan would like for people to believe. Brennan fights dirty, and he doesn't tell the truth. And what that tells me is that this trial is going to be a lot busier for me, because I'm going to have to be doing a whole lot more fact checking. Because just on the stuff that he said, I sure have pulled receipts to prove him wrong already this many times. Imagine how it's going to be when trial starts. Brennan's dirty. Yeah. Why doesn't TB stay away? I don't know. Like, he has a First Amendment right to go eat and all that. I don't know what that said I don't know anything about it, so I don't know what he said, what he did, whatever. I'm sure it'll all come out, but how long is the next trial predicted to last? They are saying that the Commonwealth expects 20 full trial days to present their case. Now 20 full trial days, depending on, not ending early and doing all that stuff. I don't know how I don't know about any of that. So we'll see. But they're saying it's supposed to be shorter than last time, but don't know if it actually will be. I hope so. Hope so. We'll see. All right. I'm going to start getting this week's episode together. I'm about to go take a break and prop my foot up for a few minutes. Oh, actually, I could work on the laptop with my foot propped up, so I'll do that. I need to go back and watch yesterday while I'm not on a bunch of pain medication. With this trial, you will have podcasts for years. Yeah. That's, unfortunately might be true. I would like for this one to get over because I know which one the next one is, and I have an announcement about all of that coming up soon. But it feels like this was never going to end. Feels like it's never going to end. Ugh. So I'll get together I need to go back and rewatch yesterday while I'm not medicated and then make my notes for that. And then I'll compare everything and I'll put everything in the podcast episode for this week. So the one that we had originally for Friday, we are not going to have now. So we will not be back together. Oh, we will not be back together on a live until the 18th. So a little less than just under 2 weeks. Yeah. And I will be I'll be tan by then. We're going to Miami and to the Keys for Chat Daddy's birthday. And as like a little emotional getaway before, or mental health getaway before this trial starts. Because Lord knows when it starts, it'll be like this. Melanie Little is going live in 30 minutes for Total Boy stuff. All right, so that's good. So anybody that wants to catch up on all that, can catch up there. Even though I couldn't chat, I was sitting here watching the train wreck. Have a good night, everybody. It was quite a train wreck. It was. All right, I'm going to go get started with all this stuff. I will have the I'll have the episode out on Friday, and maybe we'll try to do a little live on Friday since I had planned on us potentially being in court anyway. Maybe I'll do a little live on Friday and we can go over everything. Sound good? I'm not going to plan a time yet, though, because I don't really know. I'll see. Maybe I'll get some other people to come on, too. And we'll just talk about the case for a little bit. Get some opinions. Sound good? I'll see what I can figure out. All right. I appreciate y'all. If you haven't hit like, please do so. My mods get on me because I always forget to ask that or say that, but I remembered. I appreciate all of y'all, and I will see you very, very soon. Hopefully. I'll work on something for Friday. All right. I love y'all.
I gotta go. I can't stick around here forever.
Everybody was wonderful. Everybody behaved. Everybody's always so nice to me.
Just love your channel and Goodbye, good people. Now, how the heck do I get out of here?